Your phones, microphones are on. Good afternoon, lawyers. Welcome to the Appellate Division First Department. You have heard the spiel before. Please ask for on the call of the calendar, when I call your case, please ask for the time that you need, not the time that you want. Rest assured that we have read your briefs. We're quite familiar with you. We've read the record. We're quite familiar with your arguments. Don't feel you have to just go through the same arguments that you raised in your briefs. So with that, I'll call the calendar People versus Holmes. 5-1. People?
People request 5 minutes, Your Honor.
5 minutes. I apologize for I see that the monitor is blocking folks on that side. Judge Singh will be participating virtually today. So just going to have to find a way for me to hear your request for time. So 5-1 and 5 on People versus Holmes. HSBC Bank versus Russo. Appellant 5-2.
Respondent, 6 minutes, please.
Okay. Bertrand versus TKO Transport and DJM New York. Appellant?
Your Honor, appellant 5-2, please.
5-2. 5-2 on 5. New York Wheel. Appellant Mammoet Holding. I cannot hear you, sir.
Appellant request 9 and 2.
Okay. New York Wheel.
9 minutes to respond.
Okay. Baxter Street Condo versus LPS Baxter Holding.
Good afternoon, Judge. Court appellant request 8 and 2.
Do we really need 8 minutes to discuss business judgment rule? But I'll leave. I'll give you, if you can come up with 8 minutes of argument on that issue.
I don't want to say 5 and then possibly
No, but if you say 5, we're going to go, remember, the clock only applies to you, not to us. So we will ask questions past the red light.
I'll use your Honor's guidance and say 5 and 2.
Okay, so 5-2. And Baxter?
Respondent request 5.
Okay, 5-2 on 5. Morrissey versus Fresh Metal Mechanical, I understand is submitted.
Yes, Your Honor, it was a settlement last night. It's on paper. We've already done the STIP, and it'll be filed Friday or Monday.
Thank you so much. So that case is marked submitted. IKB International versus Wells Fargo. Appellant Wells Fargo.
Appellant's request 9 and 4.
IKB Cross Appellant.
Yeah, Your Honor, request 13.
Okay, 9 and 4, and I'll give you also 9 and 4. People versus Shepherd. Appellant Shepherd, 5-2. People.
The people request 6.
5-2. Okay. Hamilton v. Basketball City and H&M Hens. Appellant.
Appellant request 5 and 2. Respondent request 5 minutes.
Okay, 5-2 on 5. And People of New York versus Trump Organization. Appellant Trump.
We would request 8 and 2, Your Honor.
Respondent 10, Your Honor.
Okay, 8-2 and 10. State Farm versus Axial Chiropractic is submitted. Siami Construction versus Accurate Specialty is submitted, and Adder v. Adder is also submitted. First case on the calendar, People versus Holmes.
Good afternoon, and may it please the court. Megan Byrne on behalf of Appellate Stanley Holmes. When Mr. Holmes asked to go pro se, and the court failed to conduct the mandatory inquiry into the knowingness of that request, it violated Mr. Holmes' constitutional right to represent himself, meriting a new trial. This is a pretty low bar. Once a request is made to go pro se, we need only an
Counsel,
inquiry, and then
The court does not have to conduct a searching inquiry in all cases where there's a passing reference to self-representation, correct?
if it's a passive reference, that's correct, Your Honor.
And this was more than a passing reference? Why?
It was, and this is all kind of contained on page 22 of the November 10th transcript. But the court, the defendant, Mr. Holmes, said, "I would like to represent myself if that's possible to the court." The reason that wasn't passive is, one, it had been previewed earlier in that appearance by Mr. Holmes' defense counsel. He said, "Mr. Holmes, I think might want to go pro se."
Right. But that's exactly the point, right? The point is that defendant expressed an interest or the possibility of self-representation, but then that was followed almost immediately by his apparent agreement with the court's observation that it is not a good idea for him to do so.
Well, that's the point, is that when he said, "I would like to represent myself if that's possible," and here I think "if that's possible" is simply Mr. Holmes being polite and recognizing that, of course, it's the court who decides if it's possible. As soon as
But he didn't protest, neither did counsel, when the court say, well, it is possible, but it's very difficult. You know what they say about someone who represents themselves. And there was sort of agreement on the part of the defendant with the court's assessment.
Well, actually, twice Mr. Holmes was cut off. What he was told by the court, and I'd like to make clear, the court itself seemed to have understood this as an unequivocal request. The court said, "Even if I let you do it," and then told him all of the reasons why Mr. Holmes shouldn't represent himself.
And then after the court does that, you're right, the defendant was cut off when he made that comment about a fool, and he was about to agree, I think, with her. But then when she goes on to talk about the lawyer and what it means to represent oneself versus having a lawyer, and talking about the attributes of the lawyer who's standing beside him, he said, "I heard about that." And there's no indication, I think, in the transcript that that's a cutoff, as there is where he makes the other statement. And then she says, "Good, keep your lawyer," and he doesn't engage after that.
Well, I mean, at this point, I think what's important also is the phrasing of the court. The court wasn't just letting Mr. Holmes know what a lawyer does. The court was saying, "You can't, you're going to have to sit in your seat. You can't take the stand. You don't know how to ask questions. Your lawyer does. You're making a big mistake. You have a good lawyer. Even if I let you, I'm not going to let you talk for hours. I do a very good job." And it's to that Mr. Holmes says, "I heard about that." And the court says, "Good, keep your lawyer, bring the jury in." And at that point, as your honors know, of course, it would, at that point, Mr. Holmes very understandably understood this as a denied request. And of course, if he asked after the jury comes in, that's an untimely request.
But he had an opportunity after that to say, well, Your Honor, I want to, or his counsel, say, my client is telling me that he still wants to represent himself. Some indication to the court that the court was not successful in convincing defendant that it was a bad idea to self-represent.
Well, I think that the court's colloquy is very akin to, and the one case that I would highlight the most is People v. Trammell, where it was the same exact court that did the response They said the same things. They said, the court said, it's dangerous to represent yourself. You should try to work with your lawyer, and suggested that maybe in the future it would allow, a pro se request to go forward. It's a very similar kind of colloquy, and I don't know that we want to put too much of an onus on a defendant to, after court tells them all of this, I don't know
Right.
what Mr. Holmes could have said.
Yeah, no, I understand the reality of a defendant wanting to do something almost always in opposition to what the court prefers. But, that's the standard that we have. You saw the recent decision at the Court of Appeals. It is getting much more difficult for counsel to be requested in a very or self-representation to be requested in a very passive way. There has to be so much certainty now based on our controlling precedent that I understand the difficulties inherent in that. So let me hear from the people.
May it please the court, Michael Yetter for the people. Viewed in context, defendant's statement that he would like to go pro se if possible did not amount to an unequivocal request to self-represent.
Counsel, why isn't it exactly as counsel just explained to us, that he's merely being polite? He said, I'd like to represent myself if that's possible. I mean, he's talking to the court after all. He's the defendant. He's not in a position to demand anything. What more does one have to say other than, I would like to represent myself? So, if you please, what more?
Well, respectfully, Your Honor, I don't think that statement that the defendant made in this case is all that different from the statement made by the defendant in People v. Duarte, which was, I would love to go pro se. I think the problem is the inquiry is you need to look at the entire context in which the statement was made. And everything in the 21 pages preceding that in the transcript indicated that the defendant was primarily concerned with his sentencing outcome. He told the judge that he had pled guilty 3 times earlier in this case. He told the judge that he had pled guilty to his lawyer at some point, and his lawyer twice urged the judge to consider ordering the sentence in this case to run concurrently with another sentence. So it's clear that this statement was made after all of those entreaties had failed. Now, as to...
But you see, the difficulty with that is that based on a standard of clarity, rather than examining what the defendant's intent really is, this is in reality, a very difficult proposition, because you're asking a defendant to be articulate and unequivocal in the face of a judge telling him it's a bad idea, in rallying the very reasons why he should not do it. I thought that the defendant has a right to defend himself, and that should not be impeded, correct? So the question is, how does he convey? Usually, do you need a college degree or a law degree to be able to use words in a way that is so precise that it negates the very reason that the right is there to begin with?
No, I don't think you need those things, Your Honor. I mean, the difficulty in all these cases is you're dealing with competing rights. The right to represent oneself on the one hand with the equal and some courts say more important right of representation by counsel. And the problem here is the context. It's not if you isolate...
Well, where in what the judge says is the context made clear? Because you just said it was because the defendant was really more interested in the sentence he was going to get. I don't see that anywhere in what the judge explains, that the judge says, I understand that you want a better sentence, but that's not there. And as counsel said, clearly the judge was acknowledging by the colloquy that she had that this was really a request to represent himself. So it was certainly clear to the judge. It's just that the judge didn't go through the proper...
Well, the judge did start those warnings. She did advise him that it was a bad idea, that you have a good lawyer, that your lawyer will be better able to ask questions. And once she went through that, the defendant said, and she says, I limit jury selection very carefully, I do a very good job. And he said, I heard about that. And at that point, it's our position that he backed off from any.
Well, no, I mean, maybe he was just acknowledging, he was being respectful to the court that's going to pass sentence on him at some point, right? Or is going to have something important to do with respect to his case. So what is he to do? Well, Your Honor, notwithstanding the caution, what you have cautioned me, I nevertheless would, no, defendants don't speak that way. And he said, oh, I have about heard that, and the court took that by saying, oh, good, keep your lawyer, bring the jury in. So you don't find that problematic?
Well, as a general proposition, Judge, I might agree with you, but in this case, this was a defendant who had no trouble expressing his views to the court when he wanted to express them. So as I mentioned
So
earlier.
then that goes against what you just said, because if he wanted to say, I want a better sentence, that's why I'm asking to self-represent, that would be different. You just said he's a person who can express himself, and he expresses himself by saying, I would like to represent myself. And as to that statement, I heard about that. That's specifically in response to the last thing the judge says, which is, I limit jury selection very carefully. I do a very good job. It's pretty good. He's going to go along with the judge. Yeah, I'm not going to question you about that. You do a very good job. That's what he's responding to. I heard about that. So why does that go against his request to want to self-represent?
Well, under Duarte, Your Honor, you look not only to the words that are used. Justice Pickles, looking at defendant, the manner of his expression, his demeanor, may have believed that that was defendant backing off from the request he had previously made. He went on throughout.
But counsel, to protect the right, shouldn't we make sure that the record is clearer than it is here? She really didn't take the time to have the discussion with the defendant.
The record seems to bear out that she was convinced that he no longer wanted to pursue that course of action, and she moved on, and the defendant never raised the issue again. I think we can infer under those circumstances that he had abandoned his request that he had made previously, to the extent it was unequivocal at all.
I mean, the fact that he has heard all of the cautions that the judge has given him is not backing off. To me, that's a polite acknowledgement of, the concerns that the judge raised. You're not going to do better with the jury. That, they're not going to be more sympathetic to you. It's not going to help you, et cetera, et cetera, et cetera. So, I've heard that, Your Honor. And then she takes that, oh, he backed off. Good, keep your lawyer, get the jury in.
And then he immediately decided to accept the plea offer after the judge called for the jurors, which suggests at least that he did not truly and was not definitively committed to that position in our view. Thank you.
Thank you. Okay. Get a minute rebuttal.
Yes, Your Honor. So this, I would like to represent myself, if possible, was actually much akin to what the defendant said in Trammell. Actually, what the defendant's lawyer said, which was that he would like to assert his right to go pro se. I think the like to language is, again, just being polite. And I think it is different than Duarte to say kind of a more theoretical, like, I would love if this happened. And I think it's important here that that is what the court understood Mr. Holmes to be doing. The court clearly understood that he was making this assertion. And the court's colloquy was not about the fact that I think this is equivocal, I don't think you mean it. It was simply about the fact, I don't think you're going to make a good lawyer. And let me tell you why you're not going to make a good lawyer.
Counsel, I just have a question for you because you mentioned the Trammell case.
Yes.
And I was under the impression that in that case, the defendant, unlike the defendant here, made repeated requests to represent himself. Isn't that correct? There, Trammell, there were repeated requests, but not here. It was just that isolated remark. I want to represent myself if possible. So can you explain that?
Yeah, so in Trammell, I think that's right. The defendant in that case had to make repeated requests before it even got to the point that the judge, which again was the same judge here, gave that colloquy that was very much like that here. Here, the judge gave that colloquy right after Mr. Holmes said, I would like to proceed pro se, or I'd like to represent myself if that's possible. So clearly the court understood, I say more quickly here, that that is what was going on.
Thank you. Thank you both.
Thank you, Your Honor.
HSBC Bank versus Russo.
Afternoon. May it please the court, Mitchell Zipkin from Hinshaw and Culbertson on behalf of plaintiff appellant HSBC Bank. I submit today that the trial court should have never scheduled a Traverse hearing in this foreclosure action. We have an affidavit of service from May 4th, 2009, indicating that
Counselor, this is Judge Singh. Didn't Russo's affidavit raise an issue of fact with respect to a Travis hearing based on his description where he lived, which was contrary to what the process server said? Isn't that sufficient?
I disagree respectfully, Your Honor. With respect to the physical description, there were only minor characteristics that are subject to change. For example, on the affidavit of service, the process server identified Mr. Russo as 5'11" with black hair. The defendant in his affidavit only alleged, to challenge two minor aspects of the affidavit. He said that he was 5'8", which is a 3-inch difference, and that his hair was initially brown but would have been white on the
Well,
date of
no,
service.
he said for the last 15 years his hair has been white. In fact, he produced his driver's license, which
The driver's license
supports that.
was blurry. And
It might have been blurry, but it was white. It was a blurry white, not a blurry brown or black.
Well, a service is something that's done quickly on the doorsteps of a property where a defendant is learning for the first time that he's being served. It's not a requirement that a process server exactly pinpoint these physical descriptions down to a T. They have
It doesn't
to use
have to be, but the
their best
question is whether,
approximation.
it doesn't have to be, but the question is whether or not there was a basis for the court to grant a Traverse hearing. And there were enough facts raised to grant that hearing.
I respectfully disagree on that point as well. So all of the proofs submitted of record indicate that Mr. Russo represented to the DMV, to the bank and loss mitigation, that he resided at 756 Calhoun without any descriptor as to a floor. The first time that actually came
Maybe
up...
there was no maybe there was no request or requirement as to what floor, but clearly there were two apartments in the building.
Well, there's no proof submitted in that regard either, such as a lease, a rent receipt, a certificate of occupancy, a photo of two entrances, a photo of two mailboxes, an affidavit from a purported tenant.
But that still
tax
doesn't get
returns.
us past the fact that the person who was served was not Mr. Russo, that there were questions of fact as to that issue.
But it wasn't supported by documentary evidence to back it up. It was on the eve of sale when Mr. Russo is no
Well,
longer...
what do you mean he's not supported by, first of all, it's not required that it be supported by documentary evidence, but his license does suggest that he had white hair, not brown. That's a document, right? That constitutes documentary evidence. And is there any evidence in the record that the reason he didn't indicate whether it was first floor or second floor, that somehow he was trying to avoid service?
Well, no, and there's no requirement that he had any intent to deceive, but simply if you hold yourself out to have an address and you induce reliance, regardless of whether the intent is there to hide your whereabouts, that is sufficient for an estoppel argument where he should be precluded from challenging service. So if we go back to the beginning of the case, a few months before service in a loss mitigation application, he just has 756 Calhoun with no floor designation. 5 days after being personally served, he sends a debt validation letter. Again, no floor designation. Fast forward to 2012, he sells the property, and there's no floor designation on the deed that's recorded. Fast forward to 2014, when the order to show cause is submitted, he says he resided on the second floor in the date of service, but the driver's license also doesn't have a floor designation. And I just want to point out, with respect to the court should have never granted the Traverse in the first place, but he wasn't entitled to the property when he made the application. He sold the property a year and a half later. So foreclosure sale wouldn't have disposed him of his ownership aspect of the property. That was already done voluntarily a year and a half before. So it's...
So does that vitiate the requirement for you to serve him and for the court to acquire personal jurisdiction over him?
No, but he's no longer a necessary party at that point. At that point, the case should have been dropped as to Mr. Russo.
Counselor, this is Judge saying these are all interesting arguments, but were they raised below?
Well, no, so they weren't raised below because
So then how can we consider those arguments now?
because that's another aspect of my brief, Your Honor, in that the Travers hearing itself was never held. There was multiple adjournments, requests were made, but eventually when the process server was not produced,
The adjournments were for that specific purpose, right? For the process server to appear.
procure the appropriate witness or
Right.
witnesses for the Travers hearing.
And the court gave you one last shot to produce them, I think the fifth time that the case had been adjourned.
Correct, acknowledging that there are statute of limitations implications, and the court
Right.
had previously granted an order of reference and a judgment of foreclosure indicating that there's merit to plaintiff's case. So given that the case was filed in 2009, this order to show cause wasn't filed till 5 years later, to undo that in a mere fraction of the time, with the public policy being to decide the case on the merits, plaintiff should have been afforded additional time to procure a witness or perhaps make a motion to extend time to serve.
But you had the opportunity to, on the CPLR 306B, to seek an extension of time for service upon a good cause shown on the interest of justice.
Well,
You could have invoked Supreme Court's interest of justice jurisdiction to get that extension, but even that you didn't do.
I can't
Especially
speak
since
to
the writing
predecessor
was on-
counsel.
If I could just add to that, especially since the writing was on the wall that you couldn't find your process server. That didn't seem to change in the months of the adjournment, so the opportunity was there.
I can't speak to the strategy and decision-making of my predecessor counsel, but I did cite in my briefing to cases where sua sponte extension of time to serve have been granted in a few different courts.
Okay, let me hear from the other side.
Good afternoon, Avi Rosenfeld for the respondent Russo, if it may please the court. There were issues of fact that were raised in the order to show cause by the affidavit that was submitted by Mr. Russo. Specifically, as the panel quickly pointed to, there were issues about his height, his hair color, his age, which was decades apart. There were definitely tribal issues of fact that gave good reason for the lower court to make a determination that a Travers hearing should be held.
How was he able to dispose of the property if there was a cloud on title, right?
The notice of pendency that you're referring to it just simply notifies the world of this existing action, but it doesn't preclude someone from taking title subject
to the litigation,
outstanding mortgage. So there were definitely issues of fact. The lower court was completely correct in granting a Travers hearing, and all of the cases that are cited by the appellant go to willfulness. There was no issue of willfulness here by Mr. Russo. He specifically put down his correct address. Counsel for the appellant seems to be arguing that there should be a new higher standard imposed, that it's no longer sufficient to put down your address, but now you have to designate your floor number. That's simply incorrect, and we disagree with that position. So all of the cases that they cite in support only go to willfulness, and there's absolutely no issue here that there was no willful intent to deceive the plaintiff, the appellant here. The second point
Counsel,
is...
if I may, I want to just stick with the address because the appellant talked about the DMV, but this is certainly not a situation where Mr. Russo changed his address, had a new address, and failed to notify the DMV commissioner, correct?
Absolutely. The address always remained the same. It was always 756 Calhoun. Counsel is just arguing that he failed to indicate that he was on the second floor, and therefore, somehow, the case law supports his position that it was quote-unquote willful. We disagree. The second point is that the court should have acted sua sponte. Somehow, the court erred by not granting this sixth adjournment request after 5 previous stipulations had been granted. And the record itself does not support that the appellant, the plaintiff in the lower court, even requested an adjournment of the sixth appearance. It was previously marked final. The court had previously granted 5 prior adjournment requests. So clearly, they didn't oppose it because they understood at this juncture, at the sixth appearance, that either they were going to produce a service processor or they weren't. And likely, they just weren't capable of doing that. The last point is, they argue that in interest of good cause or the interest of justice, additional time should have been allocated. However, they don't substantiate that in their brief. They don't substantiate it because the record doesn't support, like I previously mentioned, that the
Well, I heard counsel not willing to vouch for prior counsel. Clearly, in examining the record, there's no indication that such a request was made. So asking the court to sua sponte do this, maybe even contrary to whatever strategy or course have been charted by plaintiff in this case, is not a tenable position.
So for these 3 reasons, we don't believe that the lower court decision should be affirmed and the appeal should be denied. Thank you.
Thank you, counsel.
Good afternoon again. I just want to pose a hypothetical to the court where if you're corresponding with a bank or someone else about an important matter like saving your house or some other important financial decision, you would think if you're exchanging letters, you would put your return address as a complete address so you're apprised of, timely apprised of any decision or anything that might come of it. When that happened at the beginning of the case with loss mitigation, he provided 756 Calhoun without a floor. So that's where he's representing that he's receiving mail. Then 5 days.
Counsel, if that were the only issue in contention, the court may be willing to overlook it, right? Or overlook the fact that, or focus on the fact that there was no indication whether it was one, first floor or second floor. But there's a lot more than this, right?
No, I tend to disagree. Just because
I know you disagree, but we pointed out in our questions numerous discrepancies between the affidavit that was submitted by Mr. Russo and the process server's affidavit describing the person that they allegedly served. So you just disagree that a traverse was warranted under those circumstances. But that's for us to decide, right? You can disagree.
it just seems convenient, for lack of a better word, that 5 days after being served, a validation of debt letter was served. In response to what? Likely being served with the pleadings.
Yeah.
And then he.
But that's even during the traverse hearing, he could have been questioned about how he found out about the foreclosure. In fact, he testifies through his affidavit that it was a stream of phone calls that were received by him from various area brokers telling him the house was scheduled for an auction.
But that's belied by the fact that he sold the property in 2012 on active notice of pendency was on the property. He had at least, at a minimum, constructive notice at that point that he was selling the property subject to an active foreclosure.
Okay, thank you. Thank you both. Bertrand versus TKO Transport and DJMNY.
Good afternoon, Your Honors.
Good afternoon.
I'm Joseph Powell from the Law Office of Powell, Klugeman, and Postel on behalf of the appellant DJM Transport New York Company, Inc. I'll refer to them as DJM New York for this presentation. Okay. In this case, the issue before the court is whether the plaintiff has met their burden of proof in seeking to relate back a late amended complaint. The cause of action occurred on September 11th, 2017, and the amended complaint was filed in June of 2021, 3.5 years later. The applicable statute of limitations.
We agree that it's only timing if the two entities are united in interest, right?
Well,
So the question is, maybe you want to get to that point because you have a short time. What is the difference between DGM and DGM New York?
So, Your Honor, there are several differences between these two corporations. First, they're separate owners. DJM Transport is owned by a different individual than DJM New York. They do share offices.
Mr. Banco is the owner of DJM Transport, correct?
Correct.
And Mr. Colombino owns DJM NY, correct?
That's correct, Your Honor.
Thank you.
DJM Transport hauls waste. DJM New York, my client, sells stone. So
Now, was there any attempt or any claim by plaintiffs that, seeking to pierce the veil of the two? I mean, was there any evidence taken with respect to the differences between these two companies?
No, Your Honor, and significantly, there is nothing pled in the complaint or the amended complaint of an alter ego or some type of relationship between DJM and DJM Transport and DJM New York. If the record's very clear that there's a separate ticket for the stone that was being hauled by DJM New York versus different tickets that were used by DJM Transport. There's no allegations in any of the responses brought by brought by the plaintiff of anything that would indicate a piercing of the corporate veil. The corporate form was maintained by each of these corporations, and I cited some case law for the court, specifically the matter of Mercer versus 203 East 72nd Street. In that matter, the shareholder, the officers, and the controller all were the same people, but because they kept that corporate form.
Counsel, did anybody argue below that there was a unity of interest between your client and TKO and Mr. Martinez?
There was no argument whatsoever, Your Honor, that TKO and my client had unity of interest. If you actually look at the...
But nobody argued it even, correct?
No one argued it, and no one presented it by written or oral argument, Your Honor. Yes. And actually, if you look at the judge's opinion, there's a specific footnote in there that specifically indicates that plaintiff's counsel was arguing that DJM Transport and DJM New York had unity of interest, not that TKO and DJM New York had unity of interest. And if you look at even his opposition brief to my motion papers, there's a heading that indicates DJM New York and DJM Transport have unity of interest. It's very, very clear from the papers and in the argument and per the judge's opinion that it was never argued that DJM New York and TKO had unity.
Well, they only argue that the two DJMs are intertwined and united in interest, but there's no documents or arguments put forward.
That's correct, Your Honor. The pleading itself doesn't argue it, and there are no proofs presented before the court to indicate some type of alter ego that's presented by the plaintiff.
Okay, let me hear from Mr. Isaac.
Good afternoon, Your Honors. I'm Brian Isaac. I represent the plaintiff respondent, as you know. Judge Moulton, I'm not sure I agree with what my adversary said factually about the pleadings. I think if you look at the trial court's decision, page 6, there are two separate theories. But if you take a look at page 46, paragraph 27, sentence 1, 2, 3, 4, the plaintiff said this as to the claims. Quote, first, it is plaintiff's position that a business and agency relationship existed between TKO and DJM Transport of New York for the hauling of materials on the day of the accident. Second, It is plaintiff's position that the business relationship between DJM Transport LLC and DJM Transport of New York is so intertwined and commingled that it is effectively operating as one enterprise that shares offices, staff.
Mr. Isaacs, this is Judge Singh. Mr. Isaacs,
Yes, Your Honor.
if you were to get a judgment against one of the defendant entities, how would that judgment affect the other entity?
Well, I think there's two different things. My adversary has framed my argument that way. I'm not sure that's my argument. I think my argument is, and let me bring it to you factually so I can, because I know the court has
Well, I want to try to see where there's vicarious liability, right? So that's what I'm getting at.
Sure. But there's a factual component to it too. So just let me get to it, and then I'll answer your legal question. What happened in the case is it got prosecuted like a regular case. The plaintiff gets hit, pedestrian knockdown. They sue TKO, the owner, and they sue Martinez. Martinez gets deposed, and he says, I'm hauling for DJM. We just call them DJM as opposed to DJM New York, which is fine. We sue DJM. Nobody has a problem. Gets put in. We have a discovery response post-deposition to find the tickets because we want to confirm that we have the right entity. And lo and behold, after the statute of limitations, which unfortunately happens, we get a ticket on 265 of the record. And if you take a look at 265, 267, and 268, all of a sudden there's a new company that we never heard about before called DJM Transport New York Co. Inc., which is my adversary's client. If you take a look at 266 of the record, this is important. What you have is you have an email from their counsel which says, and I'm quoting, as discussed, these are the delivery tickets DJM Transport LLC provided me. Not DJM Transport New York Co. provided me, but DJM Transport LLC. I'm not saying I have summary judgment. I'm not saying I can pierce the corporate veil. What I'm saying is we have a client, we want to make sure we have the right entity. We have a potentially vicarious liability situation depending on what that employment relationship is. And he may very well be entitled to summary judgment, but he doesn't win on a 3211 motion when I get no discovery whatsoever except for a belated email that's dated March 12, 2021, in which the attorney himself melds the two companies. I'm not saying I win. Maybe I lose, but that's an issue that I should be decided summarily, not on a 3211 motion, where
So it's your argument that it's really the attorney's mischaracterization that gives you the right to keep both entities in? And you haven't answered my question. You haven't answered my question. You get a judgment against one entity. How does that affect the other entity? Don't you have to pierce the corporate veil?
I understand your question. I don't know which entity I have the judgment against. If the event itself took place with just DJM Transport, I have a judgment against DJM. What if it turns out I lose the case? And it turns out that DJM New York was actually the entity that controlled that situation. I'm out of luck. I'm not saying I know which one actually did it, because I don't. But I'm getting discovery on the fly well after the statute of limitations came up. I didn't do anything wrong, and I'm trying to make sure I have the right entity. So to me, I don't lose on a 3211 motion. Maybe I lose on a motion for summary judgment. And my adversary's brief says 5 times, I'm going to prove that there was no agency relationship. I'm going to prove that there is no vicarious liability. That's fine. That's for another time, not for now. And not in this situation where there's absolutely no delay on the plaintiff's part at all, where plaintiff did everything right, and where the plaintiff is simply trying to protect the record to make sure that she has the correct entity in a serious leg-off injury case.
The 2001 email, the 2021 email, what part of what page of the record is that?
266 of the record, and if you follow over Judge Acosta, 267 and 268, you'll see the trip tickets that we were waiting for.
Okay.
And it's the first paragraph on 266.
Thank you, Mr.
Thanks so much.
Isaac.
Your Honor, I'll be brief. In this case, the burden was initially on me for the motion to dismiss to prove that the amended complaint was outside of time. I met that burden. Now the burden shifts to the plaintiff. So to the extent that there's one email that may indicate an issue with DJM Transport or DJM New York, that he doesn't meet his burden that way. That document wasn't considered by the lower court nor argued.
Well, there were not many documents that were considered. The lower court make its decision based on a request, or she did that sua sponte?
She made a decision that DJM New York had unity of interest with TKO on her own, sua sponte.
Right, so she sua sponte decided that there was unity of interest. There was
Right.
no request for additional information,
That's correct, Your Honor.
right? Okay,
Thank you.
thank you both. New York wheel owners?
Good afternoon, may it please the court. Anthony Ullman from Denton's US LLP on behalf of Mammut Holding BV or MBV. Your Honors, this action is precluded under sections 19.10 and 11.14.2 of the Design Build Agreement or DBA. And I'll start with section 19.10. MBV is the ultimate parent of one of the members of the DBT. And under section 19.10, that is fatal to New York Wheel's claim. Now, in an effort to avoid this, New York Wheel argues that Delaware law applies, and that under Delaware law, a claim for alter ego is an equitable claim that's separate from a contract claim, and because it's an equitable claim, it's outside the scope of an exculpatory clause.
So even on the Delaware law, do you think that those provisions, those DBA provisions, insulate you from liability for fraudulent acts? Basically aimed at depriving the creditors from recovery from the DBT.
If there were a substantive claim of misconduct by MBV of fraud, we would agree that under New York law or Delaware law, the exculpatory clause wouldn't apply. The problem is here that there's no substantive claim of misconduct against MBV. The only claim for misconduct is for breach of the DBA, which was by the DBT. And that's at paragraphs 153 to 54.
But the DBT was formed by, it's basically a shell company that's formed by MUSA and Starnet, right?
Well, it was a company, it was a company that was formed by those two companies, but it was the alleged bad actor. It was not MBV.
But Counselor, this is Judge Singh. If in fact DBT was undercapitalized, didn't maintain corporate form, isn't that a form of fraud that we can consider whether or not 19.10 gives you immunity? And if there's fraud, isn't there an argument that you shouldn't get that you shouldn't get the benefit of that provision?
No, I don't think that's correct, Your Honor, because there is certainly a public policy exception to operation of an exculpatory clause in New York. But the exception is that under public policy, that type of clause will not be enforced where the damages at issue arose from the conduct of the exculpated party that was tortious, fraudulent, grossly negligent, and transcended acceptable levels of bounds. And that's what was made clear, for example, in the Part 60 putback case, that what the public policy exception is looking at the behavior, the conduct of the party that sought to be exculpated. Did that party engage in conduct that caused damages to the plaintiff, and was that exculpated conduct, or that conduct of sufficient level of wrongness that arises to the level of fraud or gross negligence or otherwise?
Or intentional wrongdoing, right? That's what Khalid said.
Yes, but it's substantive, where it's the damages caused by the misconduct. In this case, the allegations of alter ego did not result in any claimed damage to New York Wheel. The only damages they claim are the damages caused by the alleged breach of contract by the DBT, and that was done by the DBT.
So it's not enough that they're saying that that was done caused by the defendant and Starneth siphoning off money from the DBT?
They did not make any claim of damages resulting from alleged siphoning. And I would also note that their allegations don't specifically say that MBV was the party siphoning. They make broad allegations that the DBT siphoned money.
DBT is what I said.
Okay, yes, but this claim is against MBV. That was my point, that
Oh, I see.
their MBV is what didn't do
Right,
it.
but isn't the answer to that that's why we do discovery? So we could figure out who actually committed the intentional wrongdoing?
No, Your Honor, because what you have to live by is what is alleged in the complaint. The complaint alleges the damages were caused by the breach of the DBT when it allegedly breached the construction contract. There is not a single allegation in the complaint that says, because of these allegations of alter ego, we were harmed, we suffered monetary loss. You can search, you can read the complaint 10 times over, you will not find it because it is not there. And under, as I said, under Part 60 look back, and the other cases we've cited, what you have to focus on is, did the allegations of misconduct by the party that sued cause damage? And if so, then you can look at the, whether an exculpatory clause shouldn't apply. But here, there's no misconduct by MBV that's alleged to have caused damage, so there's no basis to invoke a public policy exception in the first place.
Well, they argue or they allege that DBT is basically a shell company of SBV, right, of Starnet BV, with no assets, no employees of their own. It was undercapitalized. It lacked the capital to cover the anticipated expenses and that ultimately the defendant began providing DBT with loans in order to cover its expenses.
Yeah, but though that's not a claim of substantive misconduct that resulted in damages. Under New York law, under Morris and his progeny, alter ego is not a separate cause of action. You can't sue someone saying, you're an alter ego.
But they also say that you siphon money from DBT by hiring defendants.
They don't make
and started.
Your Honor, they don't make a claim for damages for that. Public policy.
They're saying they were damaged by all of the conduct.
No, they don't. Well, their specific claims for damages are set out at paragraphs 154 to 53 to 54 of the complaint. They say these are the breaches. The DBT breached the contract. It lists a number of breaches. It also lists a number of breaches at paragraphs, I believe, 77 through 85. And it says, we've been damaged by these breaches. There is not a single thing, because I can't say it, that we've been alleged or harmed by alleged siphoning or alleged working together. I mean, there has to be some substantive conduct by the...
Like siphoning money?
They're not alleging that as having caused them harm. There's no cause of action for siphoning.
Counsel, can't we draw
If you siphon money from the very corporation you create, that causes damage.
No, it does, they do not allege that at all, Your Honor. There's not a...
Well, they allege
second
the
claim
activity.
based on siphoning.
They allege the activity. They allege that the defendant siphoned along with Starneth. You're saying they don't carry it over and list that as one of the causes of the damage?
There's no damage caused by it.
So I'll just repeat then what my colleague asked. So if the defendant had siphoned money from DBT, that doesn't in and of itself cause damage, the siphoning of the money?
Not unless they can say they were in some way damaged. If they had a cause of action and said, we had a right, money should have been paid in such and such a place, it wasn't, it was paid somewhere else, and as a result, we suffered monetary wrong, they might have a cause of action, but they don't. They don't say that. That's not their claim. In these circumstances, under the Morris case, the only thing the alter ego allegations are there for is to try to provide a vehicle for making MBV liable for damages that they say were caused by the DBT. But it is not a substantive cause of action.
Okay, let me hear from the respondent.
Good afternoon, Hunter Mims on behalf of Respondent New York Wheel, introducing Jeff Eichmann, who has been admitted pro hoc vice for purposes of this appeal.
Okay. Welcome to New York.
Thank you for having me. May it please the court, two issues on this Section 1910 argument. First, this issue of whether New York law applies or Delaware law applies, it doesn't matter. As Justice Chan found in her order, under either theory, we still win. This non-recourse provision is not enforceable. The parties agree that under...
Counsel, is it fair to say that the alter ego allegations also have the flavor of showing that DBT was somehow disabled from completing the project, and therefore that is harm that was caused by the siphoning of money from DBT, the failure to observe corporate formalities, et cetera? Is that fair to say?
Absolutely, Your Honor. And this then goes to the second point, which is what took up the last few minutes here. They've argued that we haven't sufficiently in our complaint connected the dots, that we have this conduct that we allege that meets the alter ego standard under Delaware law, which we all agree applies. And they say, but you're not harmed by that. Well, that's absolutely untrue. The very same allegations that we plead as to why they did not did not follow the corporate form and have not entitled themselves to the distinction between the DBT and its ultimate parent, that's what led to the breaches. The reason that they didn't put enough money into the company, the fact that they didn't do that, the fact that they misestimated and misled our client about the cost overruns, the fact that they submitted these applications for payment that were fraudulent and false, that they then came to us and said, well, here's what's going on, and made various excuses for their breaches. The fact that the people doing that were for the ultimate parent who wanted to pull out of this agreement, it is all intermingled. Their breaches of the contract terms are also intermingled with the very things they did in failing to observe the corporate form. And so for them to say that our complaint needs to individually also say that everything that we allege here is also cause for damage, that's not correct. That's simply not correct. We plead various allegations of breach, various allegations that show that we're entitled to establish alter ego liability under Delaware law. And then at the end of the complaint, like we always say, we say everything up here above is what caused our damages, and we're entitled to prove those damages.
Counsel, should you talk about section 11.14.2?
Yes, absolutely. Now, the primary reason that we were successful in the motion court on this argument was based on the contract language. And the court below made a correct ruling there. That provision is meant to address and protect two different Mammoet entities that are not defendants in this case.
Right, the guarantors.
That's right. They are the guarantors under the completion guarantee. They are not Mammoet Holding BV, which is the defendant in this case.
Right.
Now, if they wanted to, if the parties wanted to draft that agreement that said, hey, you can never sue under the design build agreement if there is also a suit under the completion guarantee, they could have said that. That would be a much simpler way to draft it than to have this clause and then for the avoidance of doubt and all these various scenarios. So they're just simply not reading the contract correctly, Your Honors. The other thing I'd like to point out is this. It didn't come up in the court's order, but if you look back at the oral argument transcript, one thing that Justice Chan said during that hearing was very relevant. She said, I'm not as concerned about them double dipping because I have both cases in front of me. And what she was saying there, even though it didn't end up in her order, was look, you got two cases in front of me. Both cases have these element of damages where you're seeking cost of completion. At the end of the day, she's saying, I'm not letting you get that twice.
Right.
And we absolutely agreed to that. We absolutely agree to that. There's various doctrines that the court can apply. Sometimes it's referred to as the doctrine of double recovery or the one satisfaction rule. She can, entertain a remittitor. But we are not, at the end of the day, going to have two awards for the exact same thing, cost of completion, that are given out to both of my different clients in the different cases. The judge will never allow that, and we won't be seeking that. And the final thing I'd say here, too, is no matter how the court looks at Section 11.14.2, it cannot, as a matter of law, it cannot bar all relief that my client seeks in this case. There's an overlap in the relief that's sought in the two different cases. Costs of completion are sought in both cases. But in this case, in New York Wheels complaint, paragraph 193 and 194, as Mr. Ullman pointed out, you'll see there's other categories of damages that are alleged. General damages, reliance damages. There's even a liquidated damages claim that's in there. The fact that my other client, New York Regional, is seeking cost of completion in another case cannot possibly, under Section 11.14.2, bar us from seeking and recovering those other categories of damages. Thank you.
Thank you.
Your Honors, with respect to the argument under Section 19.10, I'd just like to point out once again that the breaching party, the alleged breaching party, is a separate entity, the DBT. It is not MBV. In the Part 60 putback litigation, the Court of Appeals wrote that in the context of a contract action, the public policy rule prohibiting parties from insulating themselves from damages, it talks about that and it says, the rule does not apply to contractual limitations on remedies that do not immunize the breaching party from liability for its conduct. That's the case here. Okay? MBV is not the breaching party. The DBT is, allegedly, and Section 19.10 does not in any way purport to immunize the DBT, which remained fully liable for anything it did. Let me turn now to Section 11.14.2, which in fact reads and was intended to read precisely on this situation. Okay? What the lower court did, there are two main clauses. The first clause says that the guarantor shall not be exposed to duplicate liability to developer for the exposures in the construction guarantee. And the lower court said that meant only that the guarantor, which is MAH, cannot be held liable under both the construction guarantee and the DBA. But that makes no sense because MAH is not a signatory to the DBA, and it's further protected from any liability under the DBA by virtue of Section 19.10, which we've discussed. So the lower courts...
And you don't think that intentional wrongdoing or fraud is an exception to those clauses, both 19 and 11?
Again, I do not read Section 11.14.2 as an exculpatory clause. It doesn't purport to exculpate anyone. It just says you can't bring a suit in certain circumstances. But if it were an exculpatory clause, I would agree that for the same reasons it doesn't apply here, because the wrongdoer is not MBV. And anyway, with respect to the second clause, so the court ended up with a construction that rendered this clause totally meaningless and superfluous, which is contrary to one of the cardinal constructions of New York contract law. And with respect to the second clause, that's for the avoidance of doubt clause in little prong 2, that clause, independent of what the first clause says, is plain and has to be enforced as written. It says that in no event shall developer be entitled to recover under this agreement with respect to any matter for which the beneficiary, regional, has sought recovery under the completion guarantee.
Okay. Thank you, counsel.
Yes, Your Honor. Thank you.
Baxter Street condo. Okay, Justice Singh is recused from this case.
It's frozen.
Yeah. He came off, right? It is frozen?
He's not moving, so I imagine that he's...
Okay, technology.
You can't see it, but I'm smiling, Your Honors.
Okay, you may proceed, counsel.
Thank you, Your Honors. May it please the court. Now, I understand that Justice Singh recused himself because of his involvement on the companion case.
We're not obligated to
right.
disclose except under certain circumstances,
Right.
but if you know he was involved in the case below, that should indicate that.
Yes, and I was in front of him on the case below many years ago, so.
Okay.
But he's frozen, so is that okay that he's frozen?
Yeah, that he's not participating in the case, and any deliberation will be outside his presence, so.
Okay. All right, thank you. To begin, yes, this case involves, among other things, the business judgment rule, but reversal is requested and mandated because if the case decision is permitted to stand, it will have a chilling effect on the application of the business judgment rule as it relates to condo board decisions as to allocations of CAM charges. The business judgment,
Allocation of
CAM charges,
camp charges.
okay? The business judgment.
Why so if that's a kind of judgment that's consistent with the bylaws and the other governing documents?
I'm sorry, Your Honor?
Why do you think that that's the case if the board decision is consistent with the bylaws and the other governing documents?
Thank you for that question, Your Honor, because
Application of judgment rule as it relates to condo board decisions as to allocations of CAM
She's
charges.
repeating, is that what she?
Business judgment, CAM
Can
charges.
you put that on mute?
Okay.
Yeah.
You're gonna have to give it twice.
I think that they're repeating.
It's she, that's her voice.
Yeah,
So
no,
we
no,
have to
it-
see if there's a way to,
Neil.
Yeah, there's a delay. Yeah, he needs to,
can he?
okay. All right. Go ahead, Counsel. I'm sorry. I'll give you an additional minute.
thank you, Your Honor. That's a very good question because the issue in here, and I want to make this distinction. In this case, the appellant is not challenging the board's authority to pass the assessment. We're not challenging the board's authority that the assessment wasn't for a condo purpose. What we're challenging and questioning is how the board calculated and the methodology utilized by the court in calculating and apportioning my client's share of the assessment as it relates to the overall
But
bill.
you don't think that that's precisely what the board's authority is, and usually one that requires a great deal of deference on our part? We're not going to get involved in calculating for the board or deciding on the calculations made by the board. Isn't that what the business judgment rule is about?
Respectfully, no, Your Honor. And in fact, that's exactly what the First Department held in Board of Managers versus 229 Condo versus JPS Realty, 308 82nd 344. In that case, there was a big, that the court distinguished between overall assessments and a unit owner's ability to be able to question and challenge a board's calculation and methodology utilized in apportioning their share of the assessment, which is what's here. And the big issue also, Your Honor, for reversal is that the argument of the business judgment rule was raised for the first time in reply.
But wasn't that because that was the first time that your client in opposition questioned the integrity of what they were doing?
If respectfully, it relates to this particular assessment. This was a special assessment and how the board, the methodology utilized by the board. My client.
But I'm saying that's when it first came up, so that's the only time that they could have responded was in reply to that challenge.
Actually, Your Honor, it wasn't, because the emails that are attached that are part of the record, and I could refer to Your Honors to record pages 151, 301, 304, 305, 306, 308, 309, 311, 357, 363, and 364. And all those record
When did you raise, I'm confused, when did you raise for the first time the issue of the propriety of the board's decision to charge the commercial tenants in the same manner as residential tenants?
in the record pages I just referenced for Your Honor. This was done way before the litigation ensued. The board was aware that the commercial tenants were objecting to being charged for items such as the HVAC in the lobby, for the tiles that were put on top of the roof, and the cost associated with the repair of the roof exhaust fans. Those line items were objected to before the lawsuit was initiated and identified clearly by my clients as being areas that were.
But you're not suggesting that in the letter that was actually sent to you, they need to invoke the business judgment rule to protect the deliberations of the board.
No, that's not what
That
I'm.
only takes place in the context of litigation, so.
I agree with Your Honor, and that's exactly it. The board was aware that we were challenging how the board was calculating the apportionment of the CAM charges to my client and alleging that that was outside of the scope of their authority and done in bad faith. That's all over and replete in the emails back and forth. And the court, when filing the motion for summary judgment, that business judgment rule was silent. The plaintiff never argued that, and we were deprived of the opportunity to be able to argue why it's not applicable here and why it doesn't preclude our client from being able to challenge the calculation and the methodology utilized by the board.
Did they send you a letter in response to your concerns about how the charges were being imposed?
And that letter, Your Honor, I don't know if it was sent or not, because that letter was attached again in reply. If this was a letter that was so important to the board's case and supported their ability to be able to apportion this particular CAM charge to our client, that says something that should have been included in their initial moving papers. And this brings me to my final point.
Why? If there was no contention that the letter had been received, I mean, it was only after you said you had not been notified of the nature of the charges, etc. Once you made that challenge, that's when they then responded.
No, Your Honor.
No, we sent you a letter in which we explained what those charges were and how we made the calculation.
Respectfully, Your Honor, that's not what happened in this case. There was contentious emails sent back and forth with the clients, especially my client and the property manager. And at one point, the property manager actually conceded that the commercial units should not have been assessed charges for the lobby HVAC system, then retracted that concession, and then that's, we were trying to get and this goes to the bad faith argument that, again, we were deprived of being able to argue because the business judgment rule was not included in plaintiff's initial moving papers and only alleged for the first time in reply. Now you understand why I asked for 8 minutes initially.
I just have a question about that, because why would they even bring that up, the business judgment rule? I mean, the bottom line is they were moving for summary judgment, so how does that have any bearing on their prima facie showing?
Because that's part of their proofs. If
No,
summary
it
judgment
isn't.
is a drastic remedy.
A board is not required to say, oh, and by the way, as an element of the prima facie case, we are protected by the business judgment rule. It's presumed that decisions made by a board is protected by the business or insulated by the business rule, absent fraud, bias, and all of the other exceptions that we know.
It's not 100% insulation, and I think what Judge Jaffe's decision does, if it's allowed to stand, what it does is it does say that now nobody could question anything the board does. You can't even attack and argue the calculations were incorrect because all the board has to do is say, oh, it's the business judgment rule, I could do whatever I want.
But that cannot be the case because boards always say, oh no, we discriminated on the basis of race, but we're protected by the business judgment rule. Fletcher said, no, just because you say it doesn't make it so, or it doesn't absolutely protect you. Or they cannot invoke business judgment if they fraudulently engage in the imposition of fees.
Yes, but in this case, and that's why the Board of Managers of 229 Condo versus JPS Realty is so important, is that in that case, the First Department recognized that it's not, when you're dealing with questioning the methodology that the board utilized in calculating the assessment to apportion to a unit owner, and if the unit owner demonstrates that the board acted outside the scope of their authority or in bad faith, the business judgment rule does not insulate that activity. In this case, we were deprived of being able to argue any of that because the business judgment rule was only, brought up in reply.
So you're saying the bad faith is the failure to assert initially that their decision was protected by the business judgment rule.
I'm saying the bad faith in this case is the fact that they refused to even consider discussing why we felt the calculations for, or the charges for the HVAC, the roof exhaust fans, and
the other items. But just to be clear, in that case you mentioned, the 229 condominium, wasn't the basis of the holding because that case lacked the business records, that the court was holding that there were certain charges and assessments for a number of years, 1991 through 1999, that lacked business records to support the amounts. So I'm just wondering if that really is why that was the case, whereas here, they had been, as you say, they had been talking about these different issues, whether it's the roof or what part, or whether it was the lobby air conditioning. And yes, they originally mentioned, yeah, the lobby air conditioning is part of it, is not part of it, and then said, wait, we have to take that back. It's not that it's not part of it, it's maybe that the whole thing is not part of it. So that was, that right there went to their why the business judgment applies. They were really thinking through the decisions they had to make for the good of the condominium. And there doesn't,
Yeah.
I don't think that you've alleged that they weren't acting under the scope of their authority under the bylaws to do so, or that they were taking action on that basis that wasn't in good faith.
And I just want to follow up on that, because in that 229 case, there were also inconsistencies with respect to the fees that were assessed. Not in this case. There was a detailed explanation. There were no inconsistencies, unlike in 229.
I thank Judge Kennedy and Judge Renwick. Thank you for that. And I just want to clarify something. Board of Managers, the reversal of summary judgment was for two reasons. One, the first department found that the business judgment rule did not insulate the inquiry and the attack by the unit owner as to how the board calculated and apportioned the CAM charges, which is essentially exactly what we're doing here. As far as the proofs are concerned, yes, it's exactly why summary judgment was not appropriate in this case, because the board, we also allege that the affidavit and the board's proofs are insufficient to support the granting of summary judgment. The affidavit from the board president fails to allege what methodology was utilized by the board in why the board was being permitted and had the authority to assess a commercial unit for the new for charges relating to a new residential lobby air conditioner, costs relating to purchasing cosmetic roof decking, and costs associated with repair of the roof exhaust.
The commercial units don't use the lobby at all?
No, not, but you know what? That allegation, that letter was for the first time again in reply, and that is why discovery was warranted in order to flush that out through discovery for depositions. And just one more thing, Your Honors.
Yeah, you've gotten about 10 minutes now.
Okay, yeah,
So.
thank you. Thank you.
Okay.
Good afternoon. My name is Maria Beltrani. I'm with Schwartz, Lacus, Reich, Greenberg, Atlas. I represent the respondent Baxter Street condominium by its Board of Managers. I wanted to start off by addressing some of the things that counsel said. First of all, as the court has remarked, the business judgment rule would never get raised on a motion for summary judgment because we don't know what the allegations are that the defendant is going to make in response to that in response to the summary judgment motion.
Okay, but let's move on from that for a minute and get to the heart of what counsel's argument is about with regard to the charges and assessments. She's saying that it's not that they considered the roof or they considered this or that or these other issues, but it's that it's the calculations and the apportionments, she's saying, that there was an issue that there's no justification for.
Okay, so with respect to that, the calculation is very simple. It was a $150,000 assessment, and all of this was laid out in the summary judgment motion. It was a $150,000 assessment. The unit owner, the appellant unit owner, had 4 units, which totaled 9.39% of the common interest, which then, if you take that from the 150, it gives you an assessment of just $14,085. That's what we're fighting about, $14,085.
Well, it is a small number relative to numbers, but maybe they're saying it should be 3,000.
No, understood, but what I'm...
small, but still, the point is...
But the point is that the calculation was made clear, and it was made clear in a number of ways. First of all, in the summary judgment motion, we annexed the declaration, which sets forth the percentage of common interest for all units. We also included the 4 deeds to the units. So the calculation part should not be an issue.
Well,
I
they
think
say
what
they
they're
only,
arguing-
they say that they only saw it for the first time in the motion papers. In fact, in opposition to the summary judgment motion, they contend that they never received a response that they requested for backup analysis to the board's decision.
Correct.
Can you address that?
Certainly. And again, this is a problem that they created. They indicated in their opposition papers that they never got any response to their agent's emails, and that just simply wasn't true. On November 18th, 2018, my associate sent a very detailed letter explaining not only the calculations, but why this commercial unit owner had to pay for things that they seemed to think were residential building things only. And it's because they were common elements. And the appellant at no time demonstrated that there was any exception for them if they didn't use a particular service, if they didn't get a benefit from a particular service. That's how that's how you would defeat summary judgment. Show me that you have an exception. They never did that. Instead, they just kept saying, but you haven't given us the calculations, you haven't given us the calculations, but that's simply not true. It was not only in the summary judgment motion, but it was in a 4-page letter rendered 2 years before. So they did know. They also rely very heavily on this 229 JPS case, and that case is distinguishable in many ways. First of all, it is true that that case was reliant upon the fact that certain underlying accounting records were not provided. That is true. But I think what also motivated this court to rule as it did in JPS is because they were fighting over whether certain residential cooperative charges could be passed on to condominium units in a CONDOP situation. And the board did not dispute that they had done this, nor did the board explain its authority to do it. So naturally, this court said, okay, well, under those circumstances, you weren't entitled to summary judgment. That's not the situation that we have here at all. Not at all.
Thank you, counsel.
Very briefly, Your Honors, because I know I had a lot of time below. Judge Acosta, you hit the nail on the head when you mentioned backup. That's another reason why summary judgment should not have been granted below. The fight between the clients had to do with the fact that the board kept insisting that my commercial unit used or somehow utilized these services that were exclusively used by the residential units. So the emails back and forth between the parties on the records that I previously indicated was my client asking, can you show us proof that the commercial units used the lobby air conditioner? Can you show us proof that the commercial units used the exhaust fans or used the commercial tiles? And the board refused. Instead,
But those are, I'm sorry.
In the November 21st letter that I think we've been talking about, they mentioned that the employees of the commercial units used the restroom that was in the lobby area. Why isn't that subject to the business judgment rule? I mean, that's a call that the board made.
well, I think the letter has nothing to do with the business judgment rule. That letter has everything to do with why summary judgment was premature and discovery should have
No,
been.
but the explanation for why the charges were made.
Respectfully, it was a self-serving letter from
It's
the
always
attorney.
self-serving.
Correct, and that's what the board, the
It doesn't
bylaw.
mean that that is inaccurate. You're not saying, no, the employees do not use the lobby bathroom.
That's exactly what we're saying. And that's,
are?
and we were deprived that opportunity because it was brought up in that letter, and then they filed the lawsuit, and we're like, listen, if you show proof that our people use the bathroom, can you just show us proof? Because we're denying that. And instead of giving the backup to support it, they just filed a lawsuit. And the Board of Managers, and just, I don't think I finished completing my answers to Judge Kennedy and Judge Renwick's
Well,
questions.
you got 4 seconds.
Okay.
so-
The proofs were insufficient. It's not about calculations. It's the affidavit by the board president failed to even give evidence that the commercial space actually utilized those services that have been routinely, exclusively used by the residential units.
Okay.
Summary, thank you.
Thank you. Thank you both. IKB International. Okay, we need, just give us a few minutes. We need Justice Singh back on. Okay. Oh,
Am I on?
I see he's moving.
Okay. I'm here.
Okay. So IKB International. Go ahead, Counsel.
Good afternoon, Your Honors. Chris Haupt of Mayor Brown for all of the trustee appellants. I'd like to start with the statute of limitations and then move on
Actually,
to...
Counsel, this is Judge Singh, and I hate to interrupt, but I would like to start with really the post-EOD defaults. And specifically, I want you to address whether or not the Court of Appeals case, U.S. Bank National Associates versus DLJ Mortgage, has any bearing on this case, which was recently decided by the Court of Appeals.
I don't think that the specific provisions at issue in that case are really...
The provisions are different, but in that case, Court of Appeals essentially held that you have to give loan-by-loan notice. How does that apply to the written notice requirements in both the PSAs and the indentures here? To the extent, I understand that there are differences, but to the extent that there's a written notice requirement, how does that apply, that holding?
Oh, well, I don't think there's any dispute that if the trustee discovers a breach of representation warranty, that has to be discovery of a loan-specific breach of a specific warranty, and it has to give loan-specific, representation-specific notice to the issuer, which means it can't do that unless it's discovered a breach at a loan level. Does that?
Well, that kind of, but the question is does the notice have to be sufficiently specific? For example, the notice gives the opportunity for the trustee to cure. So how specific does the notice have to be in order to comport with the various provisions in the various trusts?
If I could just ask, when you said loan level, is that what you meant, that it had to, when you said loan level, what did you mean?
I'm afraid we might be talking about two different things. The notice to the trustee to trigger the post-default prudent person duty is not the notice of a breach of rep and warranty that was at issue in the U.S. Bank case. To trigger an event of default, you need two notices, and this, as this court has held a number of times, always on the pleadings. First, for this particular event of default, material breach by the servicer, you need a notice from 25% of certificate holders to the servicer and the trustee and some other parties, and then you need a 60-day cure period to expire. So in BlackRock versus US Bank, for example, this court said, if you allege that the notice was given, but you don't allege in the pleading that the investors had 25% on every single trust, then we'll dismiss that claim as to all those other trusts. In fixed income shares versus Citibank, the plaintiff said, well, the trustee had a duty to send that notice itself, so we can deem it to have been given. The court said, no, that's not in the contract. So that's notice number one. Then notice number two, to put the trustee on prudent person footing, is that many of the contracts require a separate written notice to the trustee that an event of default has happened. And that's not even begun to be alleged here. That's the holding in Commerce Bank versus the Bank of New York Mellon, where the plaintiffs alleged that investors holding 25% had sent that initial letter to the servicer. But that, as this court wrote, that was a notice that an event of default could occur in 60 days if the breaches were not cured. It was not a notice to the trustee that an event of default had actually happened. And ironically, the only investor notice that IKB alleges in the case against BNY Mellon is the exact same notice that this court held was insufficient at the pleading stage in Commerce Bank. As to the other trustees, they allege very similar notices. They describe them as notices of non-performance. So they were notices to the servicer, they were not notices to the trustee. And as in BlackRock, they do not allege that those investors had sufficient holdings to actually trigger an event of default. Beyond that, they supplement the pleadings just with speculation. They say, well, there might be other notices that we have no basis at all for alleging, but who knows what we'll find in discovery. But this court has been very consistent in applying these these notice rules at the pleading stage. So if the BlackRock plaintiffs who sent the notice themselves could not get past the pleadings because they didn't have 25% holdings on every single trust, IKB cannot get past the pleadings by speculating that someone might have sent another notice. I hope that I've addressed Justice Singh's question. I think we had a disconnect at the outset, but I'm sure you'll let me know if I didn't. The only other point on the event of default claim is that they want the court to overrule all of this court's jurisprudence on the prevention doctrine. That is not warranted. Both the New York Court of Appeals and the Second Circuit have been very consistent in holding that the prevention doctrine applies only when the defendant has done something wrong to prevent the condition precedent from occurring. And that means active conduct. And this court correctly and indisputably held in fixed income shares that the failure to send a notice is not active conduct. And it's also not wrongful conduct when the trustee has no duty to send that notice. So this court's cases are a perfectly faithful application of the Court of Appeals jurisprudence on the prevention doctrine. They should not be overturned. Now, if I can go back to the statute of limitations, to start with the basics, a contract claim accrues when the elements of the breach have all occurred. And we all know that the impossibility of the defendant's performance is not an element of a claim for breach of contract. The claim accrues when performance was required and it was not tendered. And in fact, we know that this is the case in exactly this type of claim because investors brought these claims beginning in 2011, including in a case that IKB relies on for class action tolling. They brought these claims before the statutes of limitation against the sponsors expired, and all of those cases survived pleading challenges. So it's just not correct to say that the plaintiffs could not have gotten into court. They could not have alleged a breach until performance by the trustee became impossible. Here, what we're appealing on as to limitations is only, or what they're appealing on, is only claims relating to mortgage file defects. As to mortgage file defects, the trustees are required to inventory the files on the closing date. They're required to disclose breaches to the sellers on the closing date and shortly thereafter. That's what makes those claims different from rep and warranty claims. A breach of rep and warranty, you have no idea when the trustee might discover it. But with a mortgage file defect, if the trustee has failed to discover that defect on the closing date, that's because it has breached another duty, and another claim would have accrued at that point. I see that my time seems to have expired, so I guess I will save the rest of my time.
Yeah, you got 4 minutes coming back on rebuttal. So.
If it please the court, John McFerrin Clancy for the IKB plaintiffs.
Counsel, as you make your argument, I'm going to ask that you address the same case, the Court of Appeals case, and whether you feel that it's applicable to this case, the U.S. Bank National versus DLJ Mortgage.
Well, I actually think the loan-by-loan analysis, even going back to this court's decision early on in the RMBS world in Commerce Bank 2, actually is applicable to the pleadings here with regard to the post-EOD allegations. First, just a footnote, we're not talking about the vast majority of trusts here,
Right.
right?
That's the
We're just talking about
PSA
those trusts
post.
that require written notice and opportunity to cure. The reason I
Well,
say,
actually, Counsel, how many, and there are a lot of trusts here. I know that a subset of the PSA trusts do require written notice.
they do.
Is that true with the indentures, the indenture trusts as well?
Some do, yes, Your Honor.
Okay.
So I think the relevance of the case is here, every trust, all various trusts will have different requirements, different parties who have to give notice, receive notice. They're all different. Obviously, we don't know what notices the defendants has received. But what we have pled here is that they've received a lot of different kinds of notices, right? They're inundated with notices from servicers.
But let me stop you there. Isn't the issue, it's not just that they have notice. Was notice given by the correct party? Isn't that an element that is part of the claim?
Yes, Your Honor. But my point is, coming back to the analogy to what had to be shown in loan-by-loan level pleading, the court back in Commerce Bank 2, for instance, said you don't have to actually say, here's the loan, here's the defect they knew about. It was enough to show that they generally had knowledge of defects, to show, for you to get over the pleading hurdle, to then take discovery on their loan-by-loan knowledge. I think this is very analogous. Here, we're showing they're inundated with notices. We don't know all that they have, and we should be entitled to take discovery to see if as to a particular trust, they received the required form and party notice. And if you look at the cases that they cite, including some by this case, or such as BlackRock, et cetera, these are not in conflict, because in those cases, people are looking at a particular document, and they say, here's my one document that I'm relying on, and the court looks at it and says it's insufficient, right? And that's true for all the cases that they cite. Here, what we're saying is something different. We know they're getting lots and lots of notices, right?
How specific do the notices have to be?
They have to, depends on what the nature of the breach is, of the event of default. If it goes to servicer performance, it can be about it's not like a loan-by-loan breakdown. If it goes to mortgage defects, excuse me, Your Honor, a mask. If it goes to mortgage defects or failure to put back on reps and warrants, it has to be a specific loan-by-loan notice from the certificate holders.
Would you speak to the prevention doctrine, counsel?
Yes. In fact, there's no reason for this court. This court can easily reinstate our claims without doing real violence to the prevention doctrine or its prior cases in fixed income and BlackRock. One of the problems, you remember back in law school, like that 19th century negligence stuff, it was this discussion about misfeasance and nonfeasance. I dig a hole in the middle of the road, someone falls in. Is it misfeasance because I dug the hole, or nonfeasance because I didn't put a fence around it, right? This is the problem with the characterization of active versus passive. What conduct actually is active? What is passive? It becomes muddled and fact-intensive. Here, as we were able to identify later from the Pac Life case, and we've cited that to the court, which you can take a judicial notice of, excuse me, one of the defendants actually has a written policy going out to its employees to, at all costs, avoid causing the technical requirements for an event of default to arise. I think that kind of allegation should be sufficient for us to get past the prevention doctrine, even as written.
Does that square with fixed income, though?
I think it does, Your Honor, because fixed income, I believe, was just a naked failure to act, right? It was just you didn't send it. Whereas here, we're alleging something different, right? And this is what I mean why passive and active starts to get muddled and, in fact, intensive. If I have a policy and I say, look, not just that I didn't happen to send it, but make sure everybody, it's your job if you send it, so don't do it, right? I think that's a very different situation and gets you into, brings the prevention doctrine into play.
Yeah. Take a break, counsel. I can stop the clock.
Thank you, Your Honor. Let me use my last piece on this tranche and talk about the pre-EOD obligations. I'm going to refer the court to the recent decision that we sent into supplemental authority in Finkelstein v. In the Finkelstein case. There, you know, I think Justice Baraka came down last week.
We got it.
Yeah, he goes through, I think, this analysis very clearly, right? The whole problem, the allegation here, again, applies only to one category of pre-EOD claims. And the essence of it is they say, well, you can't, in some of the language of the PSAs, even though there is a right to force repurchase against the seller for mortgage defects, the party to do that is not expressly named in that section. However, there is other language that says the trustee agrees to exercise the rights above, which include this right, on behalf of the trust and the certificate holders. That seems to us to be, as it was to Justice Barak, sufficiently explicit, right? You have an express right that's in the agreement, and you have an express duty for the trustee to exercise those rights. Moreover, if you left it, if you don't read the contract that way, this very elaborate process of you get the loans, inventory the loans, schedule all the defects in the loans, becomes meaningless, right? It all becomes just surplus verbiage. And one of the central rights and protections of the trust is wholly nugatory. Thank you.
Thank you, Counsel.
Oh, John, I think you left your pen. To start with events of default again, counsel points out that you can allege sort of general knowledge of breaches, and that's enough to allege discovery of breaches. That's for rep and warranty breaches, where the standard is whether the trustee discovered a breach. In the event of default context, this court has been very clear that a servicer breach is not the same thing as an event of default. The contracts require additional actions by other parties to turn those breaches into events of default. And so in contract...
Counsel, if in fact the trustees are in possession of these various notices, why shouldn't there be discovery? And then on summary judgment, there can be a determination as to whether or not the appropriate party gave notice, whether the notices were sufficiently specific, et cetera.
Well, so first of all, just to be clear, I think that would require reversing all of this court's prior decisions on RMBS events of default, and there's no reason to do that. The Commerce Bank notice of non-performance, for example, which this court held was not even a notice of an event of default, it was on the front page of the Wall Street Journal the day after it was sent. An investor who wants the trustee to publicly declare an event of default has no reason to keep that quiet. They're not secret events of default. Event of default notices, even if the trustee sits on it, the investors make it public. And that's why in the federal cases where federal courts have completely ignored these notice requirements and we have discovery, by the time we get to summary judgment, there are never any event of default notices that weren't already publicly known. So there's really no reason to deviate from those cases. If I could speak briefly about the pre-event of default, well, maybe just a moment on the prevention doctrine, just alleging that a trustee has a policy not to do something that it's not required to do doesn't convert that into wrongful conduct. It's an omission of something that this court has explicitly said the trustee is not required to do. There's nothing wrong with that. The duty to enforce language, the trial court simply misunderstood that. That paragraph creates the elements of a trust. It says the trustee acknowledges the assignment of the trust fund, it issues certificates to identify the beneficiaries, and then it agrees to hold the trust fund and exercise the rights referred to above for the benefit of certificate holders. That means that the trustees hold the loans and also the repurchase rights, which are technically not part of the trust fund, not for their personal benefit, but for the benefit of certificate holders. They did not sort of sneak in this gigantic enforcement duty in the middle of that paragraph that's about creating the legal formalities of the trust. That's particularly clear in light of Section 801, which says not only that before an event of default, the trustee does only the things that are specifically set forth in the contract, so it doesn't have duties to do things like exercise all of your rights to protect the interest of certificate holders. But it also, if I could just finish that sentence, it also says that after an event of default, things change. And the way that they change is that after a default, the trustee does have a prudent person duty to exercise rights and powers as a prudent person does, which is exactly what the plaintiffs argue Section 206 does at all times. Thank you.
Thank you.
not arguing prudent person duties, rather that the combination, the read in conjunction, the right to put back and the exercise of rights language together may render this not an implied duty, but an express duty. I'd like to talk about the cross appeal for a minute. As your Honor see, I won't list them because it's shortness of time. All the cases other than the instant one that come up through the commercial division favor plaintiff on the issue of the statute of limitations with regard to the mortgage defect claims. What we're talking about, bear in mind, is that you have the claims I talked about before to receive, inventory, and schedule defects of the mortgage files. We call those the ministerial duties. Those have, as counsel pointed out, they have specific deadlines, dates for performance. The right to enforce and to compel the seller of the mortgages to repurchase the mortgages has no date for performance.
Wouldn't we be required to establish sort of a reasonable date, correct?
Exactly,
And what's
Your
a
Honor.
reasonable date under the circumstances?
Right, and this is why, and this is a quintessential issue of fact, and in fact, the cases that I'm talking about, MLRN, et cetera, that we cite in our briefs, that's what they said. So you have to make a reasonable determination. And if you're a trustee thinking about, should I sue now, immediately after time, there are a lot of considerations. Maybe you only have a few defective loans. You think, well, if I wait a while, I'll have more, and it'll be a more cost.
Counsel, we take that point. Can you talk about an argument that no one's raised so far, which is the tort claims? The defendant says they're not viable because of the economic loss doctrine.
Yeah, Your Honor, I believe that simply because there may be overlapping damages, first, defendants do not challenge the fact that we have stated a breach of fiduciary duty claim, right? So we have the...
No, it's about damages, and do they totally overlap?
Right.
And you say they don't.
No, that's right. And we can explore where the other damages come as we get into what they did in the quid pro quos to prejudice the position of the certificate holders. So I think, again, at this stage, where we have established the substance of the claim, to say, oh, well, the damages must necessarily overlap, it's not necessarily true. And I think it's inappropriate to dismiss at the pleading stage. I'll make a quick point on the no action clause. This is, I think, is the fourth time U.S. Bank has made the same argument, either to the lower court, the third time it's made it to this court, that even though the no action clause doesn't apply against a trustee, part of it lives on. The 25% certification number of certificate holders lives on. This court rejected that in BlackRock. This court rejected it in MLRN.
Essentially, it's demand futility is what we found in BlackRock, correct?
Yeah. And what you found, and then when a defendant has tried to distinguish that by saying, well, that you didn't have to worry about the 25% because that was a derivative case, and so all of the certificate holders were represented. But MLRN was an individual case, and this court said, under the same rule in BlackRock, you lose even in an individual case. So I think that whole theory should be laid to rest. Thank you, Your Honors.
Thank you both. Evil versus Shepherd.
Good afternoon, Justices, and may it
Just
please...
give us a second, please.
Sure thing.
Okay. Ready?
Good afternoon, Justices, and may it please the Court. Jeremy Butt from Milbank LLP for the appellant, Mr. Elliot Shepard. Mr. Shepard was convicted of second-degree robbery and sentenced to 5 years incarceration for a purse snatching in which the complainant recovers the purse minutes after it's taken and prior to any police involvement. I'd like to first address the physical injury issue. The evidence here demonstrates that the complainant did not suffer the kind of injury required to
Counsel,
ground...
didn't the injury, it manifested slowly. Would you say that's fair? It began that evening, it got worse, and she eventually was diagnosed with a strain trapezius. Why isn't that sufficient?
It's insufficient, Justice Molden, because when we look at the totality of the record and by totality, I mean the subjective evidence of injury and the objective evidence, including the complainant's own behavior, both that evening and in the following days, we don't meet the threshold, even the unexacting threshold that Chittick sets. And let me go through that evidence for you now. She doesn't report feeling any harm that
She was
night.
prescribed painkillers, though, right?
She's prescribed, yes, an oral painkiller that her doctor told her to take for a week. That's correct.
6 weeks of therapy, physical therapy?
She was, Justice Singh, she was prescribed physical therapy. She attended one session.
And she explained that. Isn't that an issue for the jury to decide whether to accept or not? And she explained why she only did 1 week's therapy, correct?
She did. She explained that she was choosing to pursue therapy for a hip element that did not prevent.
No, it's not that she chose, it's that she had previously been injured and her insurance company would not pay for the additional shoulder treatment, right?
That's correct. She chose, well, that's correct. She had a prior hip condition and she was pursuing physical therapy for that hip condition. But nevertheless, she doesn't seek medical attention for 3 days following this
That's
incident.
not a lot of time. This happened on a Sunday, and she went to the doctor on the Wednesday or something like that?
Correct.
That's not a lot of time. I mean, so she has the bruise, this thin line of bruise. There are photos that show the thin line of bruise, and I don't think that manifested maybe the first night, but somewhere within then and the next day or 3 days. She has the photos. Then she talks to her mother, the nurse, who tells her, ice it, do whatever, go to the doctor. She then later goes to the doctor. So as it was, we've already heard that she had a strained trapezius, and then she is told to take the painkillers. She actually takes the painkillers. She gets the 6 weeks of therapy, as we've already said. She's had trouble sleeping. She wasn't able to sleep. She was in pain for about 3 weeks. She had to sleep on the other side. Those are a number of different factors. So why don't all of those factors go to the injury? Why aren't they significant enough to substantiate the injury in this case?
Because here we have a number of countervailing factors. The delay in seeking medical attention, but moreover, the complainant's daily routine was not meaningfully limited.
But she was a teacher. You know, some people have some sort of surgery, or they break their arms, it's put in a cast, they're back to whatever they have to do. So that doesn't mean it wasn't a serious injury.
Correct. None of these factors in isolation necessarily mean that this was not an injury that satisfies the Chittick threshold, but cumulatively, when weighing all of the evidence, and in particular the complainant's own behavior, but also the photos that you point out, which in my submission reveal a thin and barely visible bruise, I say we do not get above the threshold set out in Chittick.
But what about also the medical records confirmed that the complainant had indicated pain radiating up to her neck, a 4 out of 10, and then it was an 8 out of 10 at its worst. Medical records confirmed those assessments, her assessments.
Yes, Your Honor. The medical records do note that she told her doctor that she was in an 8 out of 10 level of pain at its worst with a 4 out of 10 at rest. And that subjective account is one factor that the court ought to consider, but not the only one. Chittick instructs that the objective evidence, which is perhaps the most important piece of evidence, should also weigh heavily. Thank you.
Thank you, counsel.
Good afternoon, Your Honors, and may it please the court. Christian Rose on behalf of the people. With regards to physical injury, the defendant's ripping the victim's purse from her shoulder plainly caused her injuries that caused her more than slight or trivial pain. She testified in detail as to the degree and duration.
Counsel, could we pivot to prospective juror 14?
Yes.
The person, the ADA from the Bronx?
Certainly.
Shouldn't she have been struck for cause?
No, Your Honor. She should not have been struck for cause. This court's case law makes plain that a juror's mere status as an employee of law enforcement is not enough to show implied bias. That's been true of police officers, and that's been true in this court in People Against White of assistant district attorneys practicing in another county. So I think that just here, I think it's important to point out that the defendant alleges no special relationship between the prospective juror and the New York County District Attorney's
Should
Office.
the court have taken pains to explore the possibility that there was some special relationship between this particular ADA and the Manhattan DA's office?
No, Your Honor. As this court recognized in People Against Pagan, it was defendant's own fault for not asking those additional questions, and there can't be speculation as to what other relationships there might have existed between some prosecutor in another county and the New York County District Attorney's Office. And it's that close.
It's not, this wasn't a county that was upstate or something. It was the Bronx within the same jurisdiction. It's all in the first department. I think that it's a county where when one is precluded from doing the case, the other county takes the case. You know, they work together in certain kinds of cases. So doesn't that make it different than another prosecutor's office, as you say?
Well, there's a couple parts there. I think as regards to whether it, to the neighboring county, People Against White involved the Brooklyn ADA, and that, obviously, while that's the second department, it is a neighboring county. With regard to standing, I think as the appellant puts it, it's standing in the same place as a New York County Assistant District Attorney when there is a conflict. I think that underlies exactly why there is no issue with the Bronx ADA sitting on the jury. When the county law, 701, contemplates that when there is such a conflict, that it is perfectly appropriate and, in fact, is an explicitly enumerated option for a neighboring county to be involved or to be appointed as a special district attorney. If there was a conflict that was imputed from one office to the other based on their close relationship, that wouldn't be an option.
Well, not imputed, but the question is, who has the initial obligation to inquire whether there are any special relationships between that particular ADA? Has she worked in a special joint prosecution endeavor with the Bronx office or with the two offices and other district attorney's offices? Are there any links individually with that particular ADA and anything else that has happened someplace else? That's the question. And, you know, we don't go fishing, but we do have to ask the basic questions to determine whether there is bias, right?
Well, I think it's perfectly appropriate to ask those questions, but here the record gives no indication of any personal relationship. And I just want to add that it makes sense, especially as regards the New York County District Attorney's Office and the Bronx DA's office. These are not two upstate New York very small offices. There are about 500 attorneys in the New York County District Attorney's Office. There are many in the Bronx. I don't think it's reasonable to speculate that there's any personal relationship between the Bronx ADA and in the prosecuting ADA in this case.
If there was an error here, it wouldn't be if there was an error here, it wouldn't be harmless, would it? Because the defense had to use their last preempt on this juror before jury selection was done. So it would be reversible error.
We're conceding that, Your Honor, yes.
Mm-hmm.
But of course here, there was no error. This court's case law makes clear based on the law enforcement.
Does that add to the importance of ensuring that the questioning of such a juror is complete and thorough?
I think it means that we certainly should look at the record as it stands, and the record as it stands showed that the only relationship between the prospective juror and the New York County District Attorney's Office was her status as essentially an employee of the state of New York. And that's just not enough to show implied bias. If there are no other questions, Your Honors, we ask that this court affirm the defendant's conviction.
Thank you. That's I know that the prospective juror issue never came up in your initial argument, so I'll give you an extra minute to address that.
Thank you, Your Honor. And I'll make two quick points. First, on the prospective juror, we are not arguing that mere status as law enforcement warrants reversal here. Rather, The Manhattan and Bronx District Attorney's offices are understandably enmeshed in a very close and direct working relationship that includes joint prosecutions, joint task forces, the pooling of resources.
Were those questions asked, over here, were those questions asked of the juror?
No, they were not.
The questions that were asked of the juror was whether she could be fair and impartial. She answered yes.
Correct.
Which a juror would do if, if they could be. She said she could. So without those questions being addressed, how would we know whether that?
With respect to the questions that were asked and the juror's assurances of impartiality, here we're arguing that the juror was impliedly biased, and assurances of impartiality cannot cure implied bias.
So whether or not she would have worked on any sort of joint case, I mean, I don't think we even know how long she was at the DEA's office, frankly, at the time of the case, but whether or not she worked in any joint task forces or anything else, that would be enough to require her.
It would certainly help our argument if we had more detail about the nature of her specific relationship. Nevertheless,
Certainly would.
even absent that detail, we say that this relationship between the Bronx and Manhattan District Attorney's offices, as close as it is, warranted disqualification of this particular juror. And then very, very briefly, on sentence, even if this court finds physical injury and disagrees with me on the perspective.
So the range here was 3.5 to 15, right?
Correct.
He got 5.
That's right.
You want a reduction to 3.5.
Correct.
Which is the minimum.
That's right. And I see my time's up.
Go ahead, I'll give you 30 seconds.
Yeah, very briefly, this was a purse snatching. The circumstances of the offense demonstrate that 5 years was plainly excessive, and Mr. Shepard suffers from mental illness and addiction, and would be most benefited by treatment and support rather than further incarceration. Thank you.
Thank you, and the court wishes to thank the firm of Milbank LLP for your services.
Thank you very much.
Thank you. Hamilton versus Basketball City.
Well, good afternoon, Your Honors. May it please the court. I'm David Lane for the appellants, Basketball City, New York, LLC, and H&M Hines & Moritz, LP. In the court below, plaintiff's motion to vacate the dismissal of this action should not have been granted, simply because plaintiff did not meet its burden on its motion. With respect to the requirement for showing a reasonable excuse for the default, a plaintiff points to law office failure and specifically a clerical error in failing to file a consent to change attorney form. However, what we actually see is a pattern of neglect where plaintiff took no action on the case for nearly a year. Plaintiff's current counsel began its representation.
Was it plaintiff or plaintiff's counsel?
Well, I think that both are implicated here. Clearly, the law office failure occurred at the firm.
Because I'm not sure that there's evidence of the plaintiff's willful conduct. I mean, there seems to be a pattern here by counsel in not following procedures, time requirements, etc., which is all built into the law office failure finding that the lower court made.
Correct. The law office failure would implicate the law firm. However, I do think that from June of 2019 to May of 2020, after the case had been dismissed for multiple months, plaintiff's counsel had surprisingly served responses to discovery. It seems to me that the plaintiff was not inquiring of the case during that period of time. That's not explicitly mentioned, but In any event, the law office.
But we don't know that, right? I mean, plaintiff could have been calling counsel, as most plaintiffs do. What's going on in my case? What are you doing? What are you not doing? And counsel seems to be asleep at the wheel, right?
Correct. It's not evident from the record. And with respect to the second prong of.
But you agree that it is within the court's discretion to credit the proffered excuse for the default, right?
Right. The court does have discretion to take law office failure into consideration. However, it's also clear that law office failure cannot excuse a pattern of neglect.
True.
And that's kind of the distinction that we're trying to draw here. And with respect to the second prong, the meritorious cause of action, quite simply, in the motion to vacate, there was no affidavit of merit submitted or any other evidence to substantiate any merit to the cause of action other than the
Counsel, if I may, but we have the complaint, we have the bill of particulars, and then there were also authorizations provided for the medical and hospital records. So those things together, wouldn't they, set forth possibly a meritorious cause of action? All of those things.
The authorizations that were a part of discovery were not received by the defendants until after the case was dismissed. When the court below was reviewing the motion to vacate, it was reviewing only the complaint and the bill of particulars. And then in May of 2020, after the case was dismissed in February of 2020.
But it gives us a glimpse into how you were prejudiced, right? You got the VP, you got the authorization, so you can even proceed on much of the case.
Right. The prejudice here would be the year and a half delay in the case, and frankly, the action was dismissed and for several months, and the plaintiff didn't meet the burden in the first instance. I mean, in terms of the merits of the case, obviously, we would strongly disagree on that. But in moving to vacate, the standard wasn't met. I think that in a case where it's the plaintiff that's in default as opposed to a defendant, it seems that an affidavit of merit would be a superfluous requirement if all that was needed was a pleading. So that's all I have if there's no further questions.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. My name is John Blythe. I represent the plaintiff respondent, George Hamilton. So to touch on
Counsel, this is Judge Singh. Counsel, how have you established a meritorious claim in this case? There's no affidavit, so how have you shown it on this record?
Correct, Your Honor. There is no affidavit because we don't think one is required. Just like the lower court found, the meritorious cause of action is shown through the verified pleadings and the bill of particulars. And our position is that that's sufficient to satisfy the meritorious cause of action showing, and as this court has previously found, the showing of merit that's necessary to vacate a default is less than what's necessary for opposing a motion for summary judgment. And the lower court is aware of that, I'm sure, and that's why the lower court correctly determined that based on the evidence we submitted, plaintiff did show a potentially meritorious cause of action. With respect to the law office failure, my adversary just mentioned now that the defense was prejudiced by this unfortunate clerical error, but they haven't described what the prejudice is. Counsel said the prejudice is a 1.5-year delay in this case, but that's not describing what it is. You have to say why that 1.5 years would be prejudicial, and counsel did not make that argument. The case has been proceeding. We've been doing depositions. And when you consider the factors that the court looks at, all of the factors, including the extent of the delay, the prejudice to the opposing party, I submit there's none. Willfulness, I submit there's no evidence of willfulness. And of course, the public policy of determining cases on their merits, those all fall in favor of the plaintiff, I submit, and I would ask the court to uphold the lower court's decision.
Thank you, Counsel.
Thank you.
Very briefly, Your Honors, with respect to the meritorious cause of action, the cases are clear that something additional, admissible evidence is required. We agree that the standard is less than a motion for summary judgment, but something additional is required. Even if it's not an affidavit of merit, some of the cases have an affirmation along with photographs and things of that nature. But here
you have medical records. So why not medical records? Why isn't that sufficient to get them over the finish line?
The medical records were not what was considered by the lower court at the time. It's sharply in dispute. Obviously, the case is going on because the motion was granted. The motion to vacate was granted. So we can't be faulting for proceeding with the case because we have to do that. But at the time that the motion was made, the court had nothing other than the pleadings and the bill of particulars.
So discovery continue in this case. So you've had depositions, you've had access to medical records. So you're going to be ready to file a note of issue soon, right?
Well, discovery, my understanding is discovery is ongoing and additional parties have been brought into the case. But of course, we're proceeding with the case because obviously we have no choice. The dismissal was vacated. But we would disagree that there's been no prejudice. And the case was
You haven't stated any,
right,
other than your year and a half. That you haven't stated how that applies to prejudice, how that prejudiced you.
We would say, well, first of all, the prejudice is not part of the explicit standard here for vacating. I mean, it's part and parcel with the discretion, but that doesn't obviate the need.
But why don't you tell me how you were prejudiced?
The prejudice is that the year and a half delay and the fact that...
How did the year and a half delay prejudice you?
Well, the defense was trying to move the case from the time that it answered all the way through 2019, through its motion to compel, and was getting nowhere. So...
Okay. Thank you, Counsel.
Okay, thank you.
Thank you, Your Honors.
Okay, last on the calendar, People of New York versus the Trump Organization. Justice Renwick is recused in this case. Go ahead, Counsel.
Thank you. Good afternoon. I was wondering how I was going to be able to talk through this mask, but your sound system is excellent, and now I see that hopefully you can hear me. Thank you for being patient, being here at 4:15 in the afternoon. I'll try to move through my remarks very quickly, as quickly as I can. May it please the court. My name is Alan Futerfast. I'm representing the three respondents here today, Donald Trump Jr., and Ivanka Trump. It's a very interesting issue that we have here. And it's an issue that I've read all of the Attorney General's cases. I've read our cases. The issue here seems to cut in a manner and between these cases that, quite frankly, I think has never just not been addressed. And as I frame the issue, it seems to be that, according to the Attorney General, if the Attorney General and the District Attorney of New York are jointly pursuing a criminal investigation, an office subpoena is served and designed to get information to the grand jury, okay, but not through the proper grand jury process, under their theory, that's perfectly permissible. We say that's not for two reasons.
No, but see, what I hear you arguing that somehow, let me anticipate the argument.
Yes.
We read your briefs, we read the record in this case, and I hear you arguing that the Attorney General's office is really abusing their investigatory power to avoid the defendant testifying with immunity. I mean, so what makes you think that a prosecutor worth his or her salt would immunize you by asking you to come and testify before that grand jury?
Judge Acosta, that's not actually our argument. And the first thing I want to say right up front before I answer Your Honor's question is, we're here on this argument today. My ask is really just for a hearing. We asked for a hearing so many times before the lower court. We asked
for a hearing on what?
On what are the actual facts? How much communication occurred between the Attorney General and the New York District Attorney's Office?
And what authority do you cite for that proposition?
I will tell you. I cite a bunch of authority. Number one, the case of Rodriguez versus City of New York, Appellate Division case, 1993. That case held, quote, "The law does not confer upon a prosecutor the power to employ a subpoena solely to conduct an investigation or to subpoena witnesses to attend his office or any other place where a grand jury or court is not convened," close quote. Question, right? And then there's another case, Court of Appeals decision.
Was Rodriguez a civil or a criminal case?
To me, that's why we need the hearing. Because what we do know, okay,
No, but you cite Rodriguez for the proposition that somehow that authorizes a hearing to get into what is really the purview of the Attorney General's office, that by statute has been given the power to conduct civil and criminal investigation. And you want to dig into what they're doing and how they're doing it under the authority of a criminal case. That doesn't support what you're citing it.
Well, I respectfully suggest that that's why we need a hearing, because both the Rodriguez case and the Datal case, the Court of Appeals case, say you can't have a criminal investigation, you can't be part of a criminal investigation and have these subpoenas that seek evidence to other places, whether it's the DA's office or a prosecutor's office, okay? Now, Letitia James said unequivocally, this is we indicted. This is our criminal case. I didn't say those words. No one in this room says those words, but she did. And she said them over and over. She said, we're working alongside and cooperating with the Manhattan District Attorney. She said, we're doing a joint investigation. We indicted. Now, before Judge Ngorin...
But what is the, again, what is the statutory authority or precedent that you're citing for the proposition that we have the power to curtail the powers granted to the district, to the Attorney General to conduct both civil and criminal investigations?
But I'll tell you what it is. There are decisions that we cite saying that an agency cannot act to go around or do an end run around constitutional protections and legislative protections. And so, when we cited that same language to Judge Ngorin said it not only at the hearing, but in his opinion, this is a hybrid case. This is a hybrid. He recognized the Attorney General was part and parcel, basically standing in the shoes of the district attorney, number one. The second thing is, during the argument below, and we must have argued for over 2 hours, it was a 93-page transcript, Judge Ngorin said to the people, What did the judge mean by, I mean, what did Alicia James mean by we? What does she mean? He asked repeated questions. And so he said, Judge, that's why we need a hearing. If she is truly, and that office is standing in the shoes of the DA and working part and parcel with the DA, then, and she went to court. Now, you know the Himalayan case.
Counsel, does it matter that the civil fraud investigation began in 2019, well before the criminal prosecution, and was based upon the testimony of Michael Cohen?
I think it
And
matters.
then, and has gathered quite a lot of evidence since then, has thousands of pages of documents and spoken to a number of executives and other people from the Trump organization. So does that matter, that it had some momentum going before there was a criminal prosecution?
I think that I would not ask this court to discount those facts. We don't dispute that investigation started, but by the time you get to these subpoenas, July 1st, the indictment occurred on July 1st, 2021. Letitia James had announced that she was part and parcel of the criminal investigation back either in January or on May 18th of 2021. So by the time you get to the issuance of these subpoenas, this investigation, this joint investigation is a locomotive. And she's out there repeatedly saying, this is our investigation, this is our indictment, we indicted these people.
Counsel, I want to come back to your initial argument. I agree that it is proper for courts to protect against the evisceration of the privilege against self-incrimination. But what prevents you from invoking that privilege? I understand that that's a right that has been given to you by Article 1, Section 6 of the state constitution, by the CPL 190.40 section, and by other cases, People versus Courts, for example. But what prevents you from just invoking it? Why do we need to intervene in this case and interfere or constrain the ample discretion and authority given by statute to the Attorney General?
I see my light's red, but I can...
Go ahead. Don't worry. I control the clock.
Okay, thank you, Your Honor. Because we shouldn't be here. We shouldn't be in a position where someone who may have received a subpoena in violation of Rodriguez and a violation of Etal, and a violation of CPL Section 610 and CPL 19040 has to invoke. When you look at the Rodriguez case and the Etal case, the cases arising under the statutes, those cases don't say, you issued an office subpoena to the prosecutor, but that's okay, they can invoke their Fifth Amendment. Those cases say, you shouldn't be issuing those subpoenas. If you are standing in a criminal case.
But doesn't that, you know, just to go back to Justice Moulton's question to you, what is it that supports the claim that the Attorney General initiated or is using the subpoenas in the civil investigation to obtain testimony for use in a criminal proceeding?
Okay, I can answer that. We don't have a hearing, so we don't have testimony on it, but we do have their briefing, the Attorney General's briefing. And in their briefing, they put together a section, and it's cited in our briefs, and I'll read it to you, about the DOJ manual, the Department of Justice manual. And when they describe in the briefing before Judge Ngorin, specifically their response, their initial response to our brief at page 23, they describe in detail in that memorandum that evidence that evidence obtained from a civil process, criminal process, all these investigative strategies should be considered. The government has an ability to share information among criminal, civil, and agency administrative teams, including the use of investigative means other than grand jury subpoenas. So what they were doing in their briefing, the Attorney General's briefing...
So you don't think... But again, you don't have the right to be called to testify before the grand jury in a criminal proceeding, and no prosecutor worth his salt will ask you to testify and therefore immunize you, right? So that's not going to happen. So I still do not understand the question. What are the circumstances that you think entitle you to immunity from prosecution of the civil matter in light of the evidence that has already come to fruition that came out of testimony by Mr. Cohen. This was pointed out before the Congress.
When what Your Honor describes as the right, it's really more at this stage, I think we need an inquiry. And the inquiry, when you ask, well, what's the inquiry for? The inquiry is this. If you have a prosecuting official, Letitia James, wearing the hat of a criminal prosecutor, involved in a criminal case where there is a grand jury, where there are indictments already, then you have an obligation. Once you've taken that on, once you've gotten under that mantle with the DA, you've gone to court, unlike the Himmeline case, Haggerty versus Himmeline, which they cite, where the court said, I think it was the Court of Appeals, said, oh, all they did was put those two prosecutors over there. The DA didn't get, the Attorney General didn't get involved. No, here she did. She strode into court. She strode into court. I was there were a million cameras. Strode into court, sat next to the DA, and said repeatedly, I take ownership of this criminal case. Once you do that...
But that still doesn't matter. If you look at the Court of Appeals precedent, the existence of a criminal investigation does not preclude civil discovery on related facts at which a party may exercise the privilege of self-incrimination. The Court of Appeals held that in affirming our decision in Elder Dan, in Stewart. We've had plenty of precedent from this court that allow it, so I'm not clear what your argument is.
Because I don't think you've ever had a case before. I don't think you've had a case before where the other agency, in this case the Attorney General, has gone into court in the criminal case and been there in the criminal case and has said repeatedly, this is my case, we indicted. And I don't think that's why I don't think this issue has ever been presented in this posture before.
Okay.
Which why I asked Judge Engoron, let's at least find out what the facts are. Let's not have a determination. And my argument to you today is the same. Let's not, this is kind of this is unusual circumstances. Let's not, the court, I would argue, and respectfully submit, the court doesn't have to issue a decision when we don't have all the facts. I beg Judge Engoron for a hearing. What was the coordination? What was the communication? Was she really standing in the shoes of the DA? Were these subpoenas part of a plan where she spoke to the DA and said, look, I know you don't want to issue those subpoenas.
I mean, that sounds like a collateral exploration that's unprecedented. But let me hear from the Attorney General's office. You still got several minutes of rebuttal.
Thank you, Judge Costa. Thank you.
May it please the Court, Judith Vale from the New York Attorney General's Office. Under state and federal law, the privilege against self-incrimination is a shield against being compelled to incriminate yourself. It is not a sword that can be used to quash a civil investigative subpoena.
Counsel, this is Judge Singh. How do you respond to your adversary's question that, in effect, that your office is involved in a criminal investigation, a criminal matter, and it's using civil subpoenas improperly to obtain information?
Several responses to that, Your Honor. First of all, it is true that there are attorneys from the Attorney General's office who are assisting the District Attorney's office, but there is nothing unique about that. There are many situations where a criminal and civil inquiry are going on simultaneously and where the same agency is involved in both. We see this
and is there case law that supports that position?
Well, there's both federal case law and New York case law. So the federal, in the federal examples, in cases like Cordell and Gel Spice, the same federal agency, in those cases the FDA, and in Cordell it was the same FDA official was involved in both issuing the civil interrogatories and in recommending a criminal proceeding as well. And the U.S. Supreme Court said that was okay, there was nothing unfair, no circumvention, because the individuals who received the interrogatories had gotten notice that there was a risk, or at least a possibility of criminal liability, and so they could have invoked their Fifth Amendment and chose not to do so. And there are examples of this in New York as well. I want to stress that this is not unique. There are several statutes in New York that give the Attorney General's office its own criminal and civil jurisdiction, so forget assisting the district attorney. Martin Act, Donnelly Act allow the Attorney General's office to do its own investigations in both a criminal track and a civil track. And I'll give a specific case.
But you agree that courts can act under certain circumstances to protect against the evisceration of the right to self-incrimination that's set forth in the Constitution and statute, right?
Yes, I agree that courts should ensure that the right against self-incrimination is not eviscerated, but that's not happening here. Appellants clearly know about the potential for criminal liability. Eric Trump already invoked his privilege against self-incrimination in his deposition. Appellants here, the three appellants here, filed unverified answers in this special proceeding, and they said they could do that unverified because of, among other things, the potential to incriminate themselves if they put in a sworn answer. And in terms of an example of this happening and the court sort of looking in New York and making sure that the Fifth Amendment, or New York privilege would not be eviscerated, Schneiderman v. Eichner, 2016 Westlaw 3745566, was a case involving the Manhattan Club, and the Attorney General was doing both a civil and criminal investigation under the Martin Act, sought civil depositions while it was doing its own grand jury investigation, and the individuals who received the subpoenas there asked the trial court for a stay, a discretionary stay, saying, this is unfair, it's going to eviscerate my rights, and the trial court said no, because they were aware of the possibility of they were aware of the grand jury. They were free to invoke their right against self-incrimination, so that right was not being trampled on or eviscerated in any way. And there are other examples where the Attorney General's office has its own authority to do criminal and civil investigations. And so there's no need for a hearing here whatsoever, because appellants already have the information that they need to make an informed decision about whether or not to invoke their right against self-incrimination. All they need to know is that there is a risk of criminal liability. They do know that members of the Attorney General's office have been detailed.
Is there information that's outside their knowledge that they will need in order to be able to properly invoke the privilege?
No,
or avoid criminal jeopardy?
No, Your Honor. I think all they need to know is that there is the possibility for criminal liability out there, and they do know that attorneys from the Attorney General's office are, were designated to the District Attorney's office to assist. And you could look at Cordell, for example, when the interrogatories were sent there, the individual recipients all they had received at that point was a statutory notice that there was a possibility of a criminal proceeding. And that was enough for the court to say, you could have invoked. And this court and the Court of Appeals have said time and time again that the choice about whether to invoke your privilege and potentially create an adverse inference down the line in a civil proceeding, or to testify in a civil deposition and potentially create information that could be used in a criminal proceeding, that's a tough choice. But it is the choice that both the federal and New York law provide. And there is no basis for appellants to avoid that choice here.
Counsel, one thing we haven't talked about yet is that there's also a claim that this is a selective prosecution. Put aside the question about whether it's ripe or not, because you're still in an investigatory stage. Would you respond to that?
Sure, Your Honor. Putting aside that it's only an investigation, appellants here have not come close to establishing that they have been treated differently from others who are similarly situated.
They haven't offered any comparable situations, have they?
No, they have not. They have offered no comparators whatsoever. And the Attorney General's office has, by contrast, provided examples of when the office has brought 6312 or Martin Act or similar, claims, enforcement actions against large New York businesses or their principals. For example, there was an action brought against the former CEO and CFO of AIG. There's been actions brought against Credit Suisse, Exxon. When there are public allegations like the ones that Michael Cohen gave in his sworn testimony to Congress, that a large, prominent New York business has potentially been engaged in misleading statements and omissions. It is the Attorney General's statutory authority and indeed her job to investigate and to find out the truth. And that
Have the respondents or the appellants in this case, have they come up with any evidence whatsoever? I know they allude to the election campaigning statements that were made by the Attorney General herself. Do you think that satisfies the required evil eye that's contemplated by the Court of Appeals in matter of 303 West 42nd Street?
No, Your Honor, that does not satisfy that for several reasons. First of all, if you look at those statements, which are mostly from 3 to 4 years ago, in the context of what was going on in the world then, many of the statements are about official federal policies and actions that were taken by the federal administration when Mr. Trump was president. And so the Attorney General is just commenting on very public things that were happening at the time and that the Attorney General's office often brought lawsuits about. And many of the other comments, the ones that are more in the vein of potentially investigating Mr. Trump or his businesses, those also need to be seen in the context of what was going on at the time, which included, for example, in October 2018, there was a New York Times investigative piece that talked about, potential allegations of tax fraud and wildly fluctuating appraisals having been used in Trump-related businesses going back many, many years. There were also often federal investigations or other investigations going on into individuals associated with Mr. Trump's campaign or his administration. And so when you look at the statements, they're mostly about things that were happening in the world. And there's also nothing wrong, there's not an evil eye from either a candidate or an elected official saying, there have been public allegations of misconduct, and if I get elected, I intend to use my authority to look into public allegations. There's nothing wrong with that. That's the Attorney General's job, is to decide, exercise discretion to conduct that kind of investigation. And that's really the only, aside from that, which we think falls far short of showing some kind of malicious intent here, there's nothing else. And
It's malicious or bad faith intent to injure, right? Which is what, the Court of Appeals talks about in Bauer Association.
yes.
They're saying that the statements went beyond the pale, so.
Well, I don't think they went beyond the pale when you look at them in context. They're mostly, and when you look at them, there's also a theme throughout that is saying, I would intend to investigate because I don't think that Mr. Trump is above the law, or I would intend to investigate because the truth should come out. I mean, that remains true today. And on the other side of the ledger, I think we do need to look at the evidence that has come in so far, because what's being challenged here is actually just the testimonial subpoenas. The appellants have not challenged the document subpoenas. In fact, they purport to be in full compliance with them. And so the only question is whether these testimonial subpoenas at this time, 2 years into the investigation, were supported. And there is ample evidence, extensive evidence that was put into the trial court to show that these subpoenas, their purpose was to get relevant information for a civil investigation, given that that investigation has so far uncovered evidence suggesting that the financial statements are based on valuations that make misstatements and omissions, including about the size of Mr. Trump's apartment, inflated values of unsold units in another Trump building, using brand value within valuations, even though the statement said that they did not use that figure.
They sound like findings that are consistent with the testimony of Mr. Cohen before Congress.
Yes, and it was Mr. Cohen's testimony that what happened right before this investigation started. And what he said was that the financial statements of the Trump organization contain misstatements and omissions. That's what this investigation is about. It's what it's always been about. And that's what these testimonial subpoenas are about, too, because it's perfectly normal to conduct a 2-year investigation, to get documents from the company, to interview various folks from the company, and then to seek the testimony of the high-level principals towards the end of the investigation, when the issues have been, focused, when you can ask high-level officials about,
Okay.
Counsel, I have one
Justice Singh has a
How do you
question.
characterize your investigation? Is it a civil investigation, or is it, as the trial court said, some sort of hybrid criminal civil investigation? What is it here?
It is not a hybrid investigation. I don't think that's accurate. This investigation, where these subpoenas are a 6312 investigation, a civil investigation under 6312. It is true, as said in the record, that members of the Attorney General's office have been, detailed essentially to the District Attorney's office, and that they were working on grand jury investigations, but they report to the District Attorney for those investigations. What these subpoenas are in a civil investigation, and that investigation started 2 years before the Attorney General had any involvement in a criminal investigation.
Okay, thank you
I would
very
just
much.
like to end to say that, it is appellants who are seeking differential treatment here. They don't want to make the choice that the federal and New York law provides about whether or not to invoke their privilege.
Thank you.
Since I didn't have a chance to talk about the selective prosecution point, I'll spend a minute on that. But before I do, just want to say very briefly, I don't know how this court or any court can square their position with the cases in Rodriguez and Natel and the statements made by Letitia James. She says,
Okay, counsel, can you go back to Cordell and tell me, how is this case different than Cordell?
It's different in many ways. First of all, we address it in detail in a reply brief at pages 6 to 10, but it's a federal case, not a state case. CPL section 610, CPL section 190.40, those issues are not at stake in Cordell. There was no grand jury, governing grand jury law as set forth in the CPL and an issue in Rodriguez and Natal, in the Naton case, before the Supreme Court in Cordell. The Cordell court, by the way, the lower court in Cordell, held an extensive evidentiary hearing. It's in the opinion. We asked for a hearing on what happened here. The judge denied it. The lower court in Cordell did give that opinion. Finally, Cordell gave a number of exceptions to its holding, and exceptions 1, 4, and 5 in Cordell apply here. For example, exception number 4 says, well, there's an exception to the rule where a party reasonably fears prejudice from adverse pretrial publicity or other unfair injury. We've got, and I'll address this in a second if I have time on the selective prosecution, we've got years of statements by Letitia James, and I must tell you that
We have years of statements by everybody.
well, that's true, but but can I say this though? One of the parties here applied and tried to become, and did become, Attorney General of New York, the highest law enforcement officer in New York, okay? And when you take that role, and when you seek that mantle, you do not make statements like, the president is illegitimate, the president's committed money laundering, when there's not a shred of evidence anywhere on the planet that that's the case. Just wait till I'm in the AG's office. That Mr. Trump should be worried about Trish James, on and on and on. We are going to look into...
But counsel, how did
that's not
those
appropriate.
statements, counsel,
That's not-
this is
yes.
Judge Singh, how did those statements, how do they jive, or how are they connected to this investigation, as my colleagues have pointed out repeatedly, began with Michael Cohen's testimony, where there was there were allegations, certainly, but there was a factual predicate for it. Isn't this investigation separate from the statements made at earlier times by the Attorney General?
Well, first of all, the Attorney General has made those statements right up till she ascended office in January 1, 2019, and the Attorney General sought political contributions in January of 2022, and it's in the record where there's an email blast that went out saying, do you like this president? Do you support this president? Because then the Attorney General was running for governor for a short time. And it was all about political animus and using political animus against Mr. Trump to support a campaign while she's the law enforcement officer of the state. How can you do that?
Counsel, isn't there a factual predicate for the investigation based on Cohen's testimony?
Certainly, when Mr. Cohen testified and the articles they referred to, they could have an investigation. But I'm going to go back to Cordell, because Cordell said there's an exception to the general rule. And that exception is where the individual reasonably fears prejudice from adverse pretrial publicity or unfair injury. Clearly, the Attorney General just a month ago filed, or 2 months ago, filed this gargantuan filing and put thousands and thousands of confidential records online. So
what? You're saying that that's suggestive of
the
impropriety or bad faith?
I would say it's suggested of certainly being concerned under Cordell's exception number 4. And I know my light's red, but there's 2 exceptions in Cordell. Exception 5, and that is where the general rule would not apply where there's special circumstances that might suggest unconstitutionality or impropriety of the criminal prosecution. Okay, so
and what is what do you suggest is the lack of constitutional support for the criminal investigation in this case?
I would say this. I've been practicing law for 34 years in lots of cases, maybe not all as big as this one, but many cases. I have never seen the kinds of statements in 34 years that were made by someone seeking the highest law enforcement position in the state. They're simply wrong, they're unacceptable. And in one part in the brief, and I'll tell you where that is, it's our principal brief, page 34, note 34, we cite some recusal cases, People versus Adams, People versus Zimmer. All I would suggest to the court is this. First, yes, we'd like a hearing, but if the court's going to write on this, the statements made that are clearly in the record, the merging of political agendas with law enforcement, we're saying, vote for me because I'm going to go after somebody and I don't like them and I'm going to seek out everything. Those would have warranted disqualification under Zimmer, under Adams, and recusal in any local prosecutor in this state, making them a defendant.
PJ Acosta, I have a question, if I may. I just
Yes.
want to go back, because obviously Ms. Vail had already indicated that this is a civil proceeding, and certainly Executive Law 6312 only authorizes civil remedies. So when you say that this investigation is in furtherance of a future criminal investigation, it's kind of a Part A and Part B question. A, what evidence do you have of that? And certainly, isn't the Attorney General's office, don't they have the authority after this investigation to then seek authorization to commence a criminal proceeding? But first, this is civil. They're allowed to collect evidence, right?
The answer, Justice Kennedy, the answer to the first question is they have already said, and they have never denied, that whatever information they get under the guise of this civil subpoena is going to go right to the DA's office. They've never denied it. They've never said, they've never made a promise it won't happen.
And what's wrong with that? Isn't that in the normal course of business? They start, and I see them under the Martin Act and so many other statutes that support that dual civil, criminal, prosecutorial powers or investigatory powers. Generally, they start with an investigation into particular conduct that's either, sent to them, or they somehow uncover, or in some filings that are made. And then they conduct that civil investigation. If that civil investigation creates criminal jeopardy, then it creates criminal jeopardy.
But Justice Acosta, just think about where that leads. Because where that leads is if you have a CPL, Section 610, and 19040, that say that if you're a prosecutor, that's what Rodriguez says, if you're a prosecutor, you have to use the grand jury process when you issue subpoenas.
But that's with respect to criminal cases. That Rodriguez doesn't apply to the dual responsibilities of the responsibilities, both civil and criminal, of an attorney general's office. You asking us to eliminate dozens of years of precedent, or somehow act like a legislature and say, well, you're not, let's constrain the powers that the legislature has given you to prosecute civilly and criminally.
I think,
How
though.
do we do that?
Well, I think, however, when you're the Attorney General and you walk into court with the DA and you say, this is my case, and my case, and you know, and it's a grand jury investigation. So how do you do that and then issue subpoenas for documents and information that's going to go right to the grand jury or right to the DA?
But it's not like you are unaware.
But you're just avoiding the.
But it's not like you are unaware of your criminal jeopardy, meaning your clients, of course.
That's true.
In which case you can invoke the privilege of self-incrimination that's given to you by the Constitution and statute, right? That's the remedy that you have. You can invoke the Fifth.
But I do not disagree with Your Honor on that point. I guess what I would say in closing is this, because I see the red light's been on for a while, but.
No, I'm giving you plenty of time to
Okay,
vote.
thank you. What I would say is this, we should not, I don't think under those cases that we cited, I don't think we should be in that position. In other words, if a prosecutor, and Letitia James in this case is a prosecutor, she's a prosecutor, okay? Brought a criminal case, part of a criminal case, doing everything, and she's a prosecutor. And if the law is you can't issue subpoenas outside of the grand jury when you're a prosecutor, okay, then what do we do with that? You know, in other words, you can't, particularly when that
Well,
is all going to go.
the problem is you cannot avoid a civil investigation by failing to adhere or abide by the protection that's given to you by statute. If they're conducting a civil investigation, in other words, you can, and I think the trial judge mentioned this, you can't use it as a shield and as a sword. So if they're conducting a civil investigation and you will notice already that there may be criminal jeopardy involved, the only remedy that you have is to invoke your privilege of, not incriminating yourself. So you want us to somehow use the dual civil and criminal investigation to engage in some curtailment of power of the Attorney General's office. We're not empowered to do that. We do intervene under certain circumstances, and I already outlined to you what those circumstances are. I don't think that they exist here.
I will end with this citation of the Himmeline case, the Haggerty versus Himmeline, because I think in this Court of Appeals decision, I think it's instructive. Because what happened there was people did challenge the Attorney General's involvement in a criminal investigation. What the Court of Appeals said was, in that case, all the Attorney General did was task one or two prosecutors over the DA, and was involved in no other manner in the criminal case. That's what the court in Haggerty versus Himmeline talked about. And here, and said, so that was okay. The Attorney General could do that without a grant of executive authority under Executive Law 6312. That was okay, because it's just moving those two prosecutors over there, and otherwise, the Attorney General was staying away from the prosecution. That's not this case. And so where you have the Attorney General, where Ms. James has gone into court and said, no, I'm here, and I'm like a co-equal in this case, and said it repeatedly, and is sharing information, I think that provides kind of a different and maybe unprecedented circumstance.
I think you've made your point. Thank you both for your arguments. They've been lengthy and thorough.
Thank you both. Thank you all. Thank you. Thank you.
Yeah, they'll come up and do whatever they gotta do.